You would have taken me for granted. He's the senior political.
हाँ भवानी बोलो। देखो ये टाइम ऐसा केस चलता रहता है ना, ये टाइम नहीं आने का।
for you. This we heard it now. But have you mentioned to the other side? Just say that, Mr. Abhinay, request for an adjournment on the ground of personal difficulty. He states that he has informed the counsel for the appellant about his mentioning the matter for an adjournment. Re-notify him. Give it after vacation only. We'll have it after vacation, Mr. Abhinay. It's a pattern, no? Have you heard it, no? Just see the last order, man. You say we have heard Mr. Raguraman. Let's see this side only before vacation. This is a tax matter. No?
16.
Yes.
Serial number 1. Serial number 1, Shijit.
My lord, I appear for the respondents.
Yes, Mr. Neelar.
Request, matter requests, my lord. Yes, he kindly pass on, my lord, he's a captain.
Pass.
Yes, yes.
Yes.
Serial number 2. Sanmati.
Pray for a week's time, my lord.
Will you do that?
Yes,
8 objections,
2 weeks, my lord.
6 weeks,
6 months, please, my lord. Much obliged.
no office objections.
So, lordship, in the meanwhile, I may be permitted to take out notice, my lord. The learned single judge has set aside the order only on the ground that there is no sign on the notice. Entire proceedings has been quashed only on the ground that when the 148 AB notice has been issued, there is no signature
Signature where of the
on the
receipt,
notice, my lord.
on the notice of the officer who had issued
Yes,
the
my lord.
notice. But he has received it, no issue.
There is no issues. My lord. I may be permitted to serve on the counsel who has appeared in the writ petition, my lord.
The additionally, just say that the liberty is granted to Mr. Sanmati to serve a copy of the appeal on the counsel who appeared for the respondent before the ITA, before the single judge,
Single judgment.
before the learned single judge. So will you serve them?
Yes, my lord, I will serve, my lord.
Let's see, if this is, let's see this. Now,
Yes, my lord.
after this, the proceedings were held?
No, my lord. It has been completely quashed. Proceedings have been,
No. When the,
yes, my lord. After this, proceedings have been concluded, my lord.
and there was a participation from the other side.
Yes, my lord.
There was?
Yes, my lord. They have participated. The final orders have been passed, my lord.
Okay. Good. Yes,
Please,
give it, say that 2 weeks.
much obliged.
We'll have it after vacation only.
Please,
20th January, sir.
much obliged.
20th January. Serial number 3.
My lord, appear for the appellants in this matter. My lord, this matter is actually now squarely covered by the Supreme Court judgment of Canon India, my lord. In this matter, a same review.
Then those officers who are in deputation from the,
DRI,
DRI,
please, my lord. My lord, now in this matter, particularly the notice was issued under section 28 itself, directly
28.
28 only.
Unlike 124 in that
It
one.
was the earlier matter was 124.
What do you say? Louder. Louder. Ah.
My lords, time for the respondent, my lords. So it has to go back, my lords, as per the directions of the Supreme Court, my lords. I may be,
So 28 issue is covered.
yes, my lords.
Now you have anything to say on merits?
Not on merits, my lords, but I may be given liberty to my lords to challenge before the CGST Act.
Let's see that. It's only on 28 based on canon, they set aside.
Yes, please, my lord. My lord, the relevant portion is that in page 72, my lord.
72.
Learned single judge's order.
But tell us one thing.
Please, my lord,
Mr. Chauhan,
please.
then on the other aspects on the merits of the thing need to be looked into.
My lord, in this matter, the petitioner came up in appeal on solely on the ground that it is barred by limitation, my lord. But during the course of arguments, it was brought to the notice of the Honorable Court that now the DRA officers are not proper officers as per the Honorable Apex Court judgment.
So the competency was not there.
So the Honorable Learned Single Judge looked into the Canon India and solely based on the Canon India passed an order that he is not the proper officer.
So his submission is now.
Please, my lord.
So Canon India will ensure the competency of the officer who issued notice of 28 would not be gone into.
Please, my lord.
Competence was there.
Yes, my
Now, based on that, some orders have been passed also.
lord. Please, my lord.
Those need to be looked into by the learned single judge, or it will be before a
My lord,
CGST Act.
it will be before the CGST Act, my lord, because in review, my lord, Canon India, clause D, Honorable Supreme Court himself itself has said that all those matters which are pending in appeal or anything has to be remitted to the CGST Act with liberty. So the any assessee can challenge it before within 8 weeks. That is what they have given. If
We'll give you 8 weeks.
Yes, my lords.
You'll go.
Yes, my lords.
Now, this will take care of all these appeals.
all these appeals, my lord.
3.3.
Yes, my
Yes, my
lords.
lord.
Are the council there?
Yes, my lords.
In all,
All the.
Yes.
just say this
D, my lord, if I read, is it
Canon India.
Canon India review?
Review.
Yes.
Just give us one judgment.
Yes.
Just say this, the learned counsel for the appellant would submit that these appeals arises from a from a, is it a common order?
My lord, two petitions are common, my lord, other two are.
Arises from the order passed by the learned single judge in the following writ petition. Just take the numbers of the writ petition and the orders dated so and so. And the proceedings, and the learned single judge has set aside the proceedings. Set aside the orders, proceedings oblique orders
Please.
passed by the appellants herein only on the sole ground that the issue is covered by the judgment of the Supreme Court. In the case of Canon India Private Limited versus Commissioner of Customs, 2021 SCC Online, SC 200, in as much as the notice issued by the officer under section 28 of the Customs Act was not competent.
Not a proper officer. Proper officer.
Was not proper officer as is contemplated under section 28. The learned counsel for the appellant states that the said judgment of the Supreme Court has been reviewed by the Supreme Court, vide order dated, reported as 2024, 24 Syntax 117 S Supreme Court, SC, wherein the Supreme Court has held that an officer of the revenue intelligence who is working in customs.
DRI, my lord, Department of Revenue Intelligence.
No, an officer in DRI and according to him, the Supreme Court has held an officer, there are no show cause notices issued by DRI officers shall not be invalid. The officers of the DRI are proper officers for the purposes of Section 28 of the Customs Act,
Conclusion, first paragraph.
of the Customs Act. Or they just say this, or just cut it, officers of the DRI, comma, commissionerates of customs, bracket preventive, comma, Directorate General of Central Excise, Intelligence, and Commissionerate of Central Excise, and other similarly situated officers are proper officers for the purpose of Section 28. This submission of learned counsel for the appellants is acknowledged by the learned counsel for the respondents in all these appeals. Full stop. In fact, the learned counsel for the respondents make a request that as where is the liberty
Subclause.
granted?
Subclause D, my lords.
Subclause
D.
D. Roman 3, 6. C, na, 3C, 6C. 6C has drawn our attention to paragraph 168, Roman 6, C, which reads as under to contend that that the similar liberty be granted to the respondents herein to prefer appeal before the Customs, Excise and Service Tax Appellate Tribunal
Yes, ma'am.
within 8 weeks from today.
Okay.
Okay. If that be so, comma, the appeals are allowed, the impugned order passed by the learned single judge in all these appeals are set aside. Full stop. Liberty shall be with the appellants to file appeals before the CGST.
Respondents.
Respondents, sorry. Respondents to file appeals before the CGST, impugning the final orders passed on the notice under Section 28 of the Customs Act. Are these, no, I just want to know, we just want to know, come to para 37. We should have a clarity. Final orders have been passed in all these matters.
No. That's originally we were issued with a show cause notice, my lords. We participated in the adjudication proceedings. Order original was passed. Against the order original, my lords, we have preferred an appeal, petition before them.
That's right. That's why, see, that's what. But in any case, in all the original orders are in place.
Yes.
Order in original in place.
Yes, my lords.
So that's the final order under section 28.
Yes, my lords.
So you had come thereafter.
Yes.
So we take that submission. Full stop. Okay. What did we say? Impugn the order in original. Orders in original
Yes.
passed in these appeal, passed against the respondents before the sestat within 8 weeks from today. Full stop. It goes without saying that on filing of such appeals, the sestat shall decide the appeals in accordance with. Appeals are disposed of
Obliged, my
for
lords.
cost.
Obliged, my lords.
And this. Yes,
Serial number 4, Srinivas Shetty.
it's a very short issue. What is the difficulty? Ma'am, you are appearing for the respondent. What do you have to say on this? But where is the bar? Where is the bar for not passing an order? So the liability pursuant to the demand would arise only if no appeal is filed.
Yes.
So, and that appeal period is 60 days. So what you are contending is inbuilt in this provision of 60 days, there is a stay. Or at least till such time within 60 days, you cannot make any recovery or demand.
Departmental instructions are there to be expired of the appeal period before the recovery action is initiated.
So that 60 provision says so that during this 60 days, no recovery can be effected. Just say that at the request of counsel for the just say this, a request for adjournment is made on behalf of the counsel for the appellant. Re-notify, just give next Monday.
1612. Serial number 5, Shri Sanmati.
Yes, Mr. Tiwari, you have to serve the other side, huh? Now, is this issue not covered? Anything pending need to be looked into? Not covered? Maybe you will accept notice? Just say that though service could not be, so notice could not be issued for want of PF. So-and-so appears for the respondent, states that she has instruction to accept notice for the respondent. Let a copy of the appeal paper book be given to the counsel appearing for the respondent within 1 week. List this appeal for hearing on.
30th January. Serial number 6, Shri Sanmati.
This, in whose favor? What do you say, Mr. Suryanarayana? You cannot disagree with him. Or would you like to?
Followed 2 decisions on this on the court. And to my knowledge, that you have not prepared it.
Just say, let's see that.
Yeah.
Let's see the order of the tribunal. This is
First issue, what's the order of the tribunal on page 8, paragraph 4.2?
Mhm. Memphis Limited, Memphis Limited. Emphasis. Yeah, that's right. Memphis,
The issue was whether clauses on revaluation of forward contracts, so that can be taken as a study. So the this on the report in emphasis following the quotation report and in favor of this, which is what the title follows.
Is it admitted matter? No, no. Has it been admitted?
No, man, it's not, it's not. No, man, it's not been admitted.
They say this is the challenge in this.
And then the second issue was,
Okay.
there's one more question.
This is 4.2 is one. Disallowance.
Yes, para 6.2 at page 10. The issue was whether there can be disallowance under 48 IA on home depreciation of computer software. This one will go with carrying software held in favor of this carrying solution. That's what has been followed for the right at para 6.2.
And no appeal against this order.
Not that we are aware, my lords. We are not aware of it, my lords. I'll just leave
Who
it
will
at that.
file an appeal, Mr. Tiwari? You have to file
My
a
lords, we circulate that, we recommend, my lords, the filing of an appeal, but the Delhi will take over, my lords, from here on.
pardon.
The-
There it
Yes,
is
my
done
lords.
there.
The decision is taken at that level, my lords.
But you have no information. You have sent it from there here
Yes,
to
my
there.
lords. We've not got any information, my lords. There's nothing.
We go with it.
And these judgments are which year? This Memphis and
2021.
Tally Solutions.
2021.
Much water. Just say this. This appeal has been filed challenging the order passed by the IT Income Tax Appellate Tribunal, IT in short. In appeal in ITTP A number 705/bang/2016 dated 23/5/2022, whereby which is an appeal filed by the respondent herein, whereby the ITAT has allowed the appeal primarily on two issues which arose before it in favor of the SSE. The memorandum of appeal raises the following questions of law. That would be page 4 and 5. Two questions. On both the issues which have been raised by the appellant revenue in these cases, in this appeal, have been dealt with by the ITAT in paragraph 4.2 and 6.2, which we reproduce as under. Full stop. Suffice to state that on both the issues, the ITAT has relied upon the judgment of this court in the case of Memphis. What is the emphasis? What is the full citation we have here? Yeah, PCIT versus Emphasis Limited, 2021, 128 taxman.com, 138. And in the case of PCIT versus Tally Solutions Private Limited, 2021, 123 taxman.com, 21, Karnataka. Stop. Mr. Tiwari appearing for the appellant revenue states that it appears that the the judgments on both the issues of this court have not been taken in appeal before the Supreme Court. If that be so, the issue, he also does not dispute, he does not contest that the questions which have been raised in this appeal are not covered by the judgment of this court, referred to above. If that be so, for parity of reasons, the appeal is dismissed against the revenue in favor of the SSE respondent. Appeal
Because
disposed.
on the Supreme Court, my lords, I don't have the knowledge, my lords.
I say it appears.
It appears, yes.
It only appears.
Yes.
Okay. That benefit of doubt will be there.
Serial number 7. 7.
There is delay of 316 days, my lord. I have filed the additional affidavit also, my lord.
Yeah, there are quite a few matters, Mr. Sanmati.
Yes, my lord. In serial number 7, I already filed the additional affidavit, my lord.
What do you say, ma'am? Pardon? We'll allow it. What is the issue?
Your lordship, issue is, my lord, the addition has been made on the basis of the incriminating material obtained in the search, my lord. Your lordship, the tribunal has set aside the addition on the ground that the assessee who has received the amount, my lord, in respect of the future years, it will be shown as income. But your lordship may kindly see, when the assessee was a conforming party in the sale deed, he has received certain consideration. Whether he, because of the litigation in the future years, whether he will show it or not, that's not the question. For the first present financial year, there is an income. Yes, he should have filed the return of income, whether it is a liability or asset, there should be return.
Just say this. This is an application filed by the appellant seeking condonation of 316 days delay in filing the appeal. For the, have you filed any additional affidavit?
Yes, my lord. Yes, my lord.
For the reasons stated in the affidavit, oblique additional affidavit in support of the prayer for condonation of delay, and the learned counsel appearing for the respondents had left it to the court for a decision on this application. We deem it appropriate to condone the delay of 319 days. The application is disposed of. We'll stop. We'll admit it.
Question 1 and 2, my lord.
Admit
1, 2, and 3.
the following questions arises for, substantial questions of law arises for consideration in this appeal. We stop. Would you like to file any submissions on this?
No, my lord. At the time of hearing, my lord, we'll.
We'll list the appeal for hearing on. Just give it in.
20th January. Serial number 8.
Lordship, serial number 8, my lord, during the course of at the time of hearing, my lord, we'll file the necessary compilation, my lord. Because it is 2023 matter, we don't know what will be the development at that stage, my lord.
No,
Transfer pricing
no,
issue.
8 is also delay is there for 222 days.
Your lordship, delay, my lord, I will rely upon the affidavit filed along with the application, my lord.
Let's see the affidavit, Mr. Sanmati. Yes, 1 minute.
Shown the detailed process, my lord, because these are all 2023 matters, my lord. What happened from 2020 March to 2022, there was COVID, my lord. After that one, my lord, the limitations period were extended, my lord. The assessing authorities were burdened with additional work, my lord.
Are you saying that that suo moto 3 would be applicable here?
No, my lord, I'm not saying that. I'm not relying upon that proposition, my lord. Your lordship, the 2 years work which came to halt, my lord, were extended after 23 because of extension of the limitations. Because of that, the assessing authorities could not give sufficient
But you would like to file additional affidavit or let her file the objections?
Your Lordship, it is 222 days, my lord. Less than a year.
Leave it on you, you want, otherwise let her file.
Yes, my lord.
Then you can file a response if at all,
Yes, my lord.
right?
Please, my lord.
Just say this, you may show the last orders. Though on the last date of hearing, we had granted time to Mr. Sanmati to file an additional affidavit in support of the application seeking condonation of delay, he states that he shall rely upon the affidavit already filed in support of this application. Mr. Tribunal counsel for the respondent seeks and is allowed, how much time, ma'am? A week's time to file objections to the application. Full stop, if need be, rejoinder, if any, be filed within 2 weeks thereafter. Re-notify.
20th January. Serial number 9.
Your Lordship, serial number 9, 14 and 15 are all connected matters, my lord. In this case, my lord, the assing authority who has signed the affidavit in support of the application, my lord, has been transferred. Now the other officer has come, my lord. Therefore, he cannot file a better affidavit because officer has changed. Your Lordship, what I will do is I request this honorable court to permit me to file a fresh affidavit, my lord, of the present officer. I will do it in the course of the day itself, my lord.
My lords, I have a submission to make.
Yes.
My lords, kindly see, when these were filed, it was already 461 days. The issue in this case is whether the receipts that consideration that I received for sale of software is royalty or not. The Honorable Supreme Court has held in our favor in 21. Review petitions have been disposed of in 24. In 23, Honorable Supreme Court, in another case where we appeared, has clarified that even without the review being disposed of, the earlier 3-judge bench decision is binding and is fully operative. Now, in these circumstances, if a fresh affidavit is filed now, the delay in refiling will also have to be considered. So it will be about 700 or 800 days delay on a simple issue on whether sale of software will amount to royalty or not. With great respect, my lord, this is causing a lot of uncertainty. And secondly, we are not served with the copies of the appeal or with the affidavit to enable us to even bring our objections on record of the Honorable Court for consideration.
You serve them the appeal. No?
Your Lordship, I was not aware about this one, whether because it is batch of cases, my lord, 1, 2, 3. There are totally 7 cases are there, my lord. Today only 3 cases are posted.
9.
Your Lordship, 9, 14 and 15, my lord.
Mr. Rao, you are appearing in the other appeals also?
Yes, my lord. Yes, my lord. This is of the same SSC for different assessment years. Honorable Tribunal has followed the Supreme Court decision and after discussing the facts, found that the facts are identical and therefore allowed it. No substantial question of law. With great respect, we realize, my lord, it is actually a factual matter, if at all. And they didn't object before the tribunal.
We do one thing, Mr. Rao. First, take the copies of the appeals.
My lords.
Look into them.
My lords.
Now those other 9 matters are listed, other 6 matters.
I will file a memo to batch to club all the matters.
Get it clubbed.
Yes, my lord.
Get it clubbed. And you must examine Mr. Sanmati what he is arguing, whether the matter has been attained finality before the Supreme Court.
Your Lordship, as far as engineering analysis case is concerned, my lord, we have filed the review petition. In review petition, in case of engineering analysis is pending, but review petitions filed in respect of connected matters have been disposed of. Your Lordship, dehorsed that review petition, my lord, on the basis of the principle laid down in the engineering analysis itself. I will argue the case, my lord, on the ground that it is the observation, the principle has been in favor of the revenue and the royalty is applicable. Tax levied by the revenue is correct, my lord.
But this is a huge delay otherwise.
Your Lordship may kindly see, because of Your Lordship, what has happened in this case, this is also 2023, my lord. After COVID, these matters have been taken up. For one more reason is that, my lord, when the 2021, the engineering analysis case was disposed of, we filed the review petition, my lord, and the case was pending. We thought that it will be disposed of, but till now it has not been disposed of. Once it was posted before the Supreme Court, my lord, it was the notice was issued and it was said that in the next time it will be disposed of. But till now it has not been posted. But
Lords, may I say something? May I say something?
I will complete my submissions further.
Okay, sorry.
And as far as engineering analysis case is concerned, the Honorable Supreme Court has said it was dealing with a case relating to software, sale of software. If the non-resident company sells a software to the resident company, my lord, if the non-resident company does not give any specific right to duplicate the copies, suppose only one software is issued and the company who buys the software in India and resells it, then there is no royalty. But the Honorable Supreme Court has said, my lord, if the buyer, who is the resident of India, buys the software and gets the power to duplicate the copies, then royalty is applicable. But in this set of cases, my lord, the tribunal, your lordship, one of the matter in this batch itself, my lord, this was the Assessing Authority has passed final assessment order after disposal of the engineering analysis case, and he has distinguished it. In this case, what the assessee does is not the non-resident company gives the supplies software to the resident company like Wipro or HCL. When the software are supplied, the resident company, after taking the software, they make value addition. When value addition is made.
One thing then, in the meantime, you give a copy of the appeals to Mr. Rao.
Yes, my lord.
Okay. And we can permit you to file additional affidavits.
Yes.
And possibly you can file a memo also bringing those appeals.
Yes, ma'am.
There are no dates in there.
No dates.
Then so that at least everything can be clubbed. We
Yes,
say
ma'am.
nothing on
I
the
will
memo.
file a memo, my lord. It can be taken up for disposal, my lord, in the
To
connected.
just ensure it, we fix a date in these appeals.
Yes, my lord.
So that those matters which are not listed are listed on the date fixed.
Please, your lordship, instead
My
of
lords, I would
filing
like to
that-
say something.
Yes,
If
yes.
my learned friend has completed.
Yes, yes.
Well, let's kindly see. One, a statement is being made that permission has been granted contrary to Supreme Court decision to amend the software program. Well, this is fundamental. The tribunal has examined it. It's a fact that they have recorded that in the agreement there are clauses directly and compared it with Supreme Court and decided. Secondly, my lord, the reason being given before this court, how fair it is, I do not know. One of the grounds says a review is pending. When you take a ground for review is pending, you don't hold back the appeal and cause delay and give that reason as a reason for delay, my lord. In the ground, the question of law framed and the ground taken is the review is pending. Now that
You
means you are
think-
filing pendants during pendency of it. Kindly see,
Mr. Rao,
my lord.
better would be take the copies of the appeals.
Very well,
look
my lord.
into them. Look
Very
into
well,
them.
Very well, my lord.
Very well. We will see it. Suppose for a moment review the issue is pending before the Supreme Court. Let's assume hypothetically. Then possibly either these appeal be deferred. Be deferred to await the outcome, which will have a bearing insofar as the outcome of this appeal are concerned. If the review has been decided, what you are saying is if it has ultimately have been decided in favor of the SSC against the revenue, the consequence will flow.
Yes, my lord. I'll file that copy where the review has been dismissed also in April 24.
Just say this, we can take all these appeals together.
Yes, I will file a memo with all the numbers, my lord.
Say nothing, but you get it, file a memo for the date fixed.
Yes, your lordship, I may be permitted to file fresh affidavit, my lord.
That we are saying. Just
But
say
my lord,
this.
if that permission is given, they will have to consider the refiling delay till now because the appeal is in defect purposely. It's not by an error that the defect has occurred. They purposely kept it pending. If they are allowed now to file a fresh affidavit, then today the appeal is coming on record. So the interim period will have to be added to the condemnation of delay.
Simple, Mr. Rao.
My
If
lords.
they are filing the affidavit, they have to explain the delay.
Till date.
They would also say when was the appeal pending and when was the appeal was listed before the court for the first time. That surely will show that they have been just filed it and they kept it pending in the registry.
Obliged, my lord.
Just say this. Mr. Sanmati states that though an affidavit has been filed explaining the delay, but by an officer who was posted, by an officer who had filed the appeal. Since the officer has been transferred and a new officer has come,
Yes,
he intends to file an affidavit of the officer who is in place,
yes.
explaining the delay. How much time?
Your lordship, I will file it within a week, my lord.
Within 1 week from today. If that be so, the copy of the appeal along with the additional affidavit,
Yes, my lord.
which is intended to be filed by the appellant revenue, shall be given to Mr. Rao Within 1 week, within 1 week from today. Full stop. List the appeals, these 3 appeals for hearing on. This would be item 9, 14 and 15.
Yes, my lord.
Okay, re-notify.
Obliged, my lords.
Mr. Rao shall be at liberty to file a response to the affidavit oblique additional affidavit.
Yes, my lord.
Grateful to my lords.
Within, just say that within 1 week thereafter,
Yes, my lord.
within 1 week thereafter.
20th January.
Yes.
Number 10.
In this case, I filed the better affidavit, my lord.
Mr. Sanmati seeks and is allowed 2 weeks to file.
Your lordship, it is already filed, my lord.
Have you filed it?
Yes, my lord, better
Ah.
affidavit is filed.
Okay, what is that? Ma'am, you have filed any objection to this? Additional affidavit in support of the application seeking condonation of delay has been filed by the appellant's revenue. By the appellants, just say that by the appellants. What do you want? A copy thereof has been given to the counsel for the respondent who seeks and is allowed 2 weeks to look into the same, make her submission, and if need be, file an objection, file a response to the same.
13th January. Serial number 11.
Your lordship, filing of written submissions may be dispensed with for time being, my lord. We will file it at the time of hearing, my lord.
Is it admitted matter? We'll just take this. Is it admitted matter? Same issue, you know, the other matters also.
Your lordship, it depends upon facts of each case, my lord. But here, my lord, I don't know, my lord, because I have not read the entire file. In those cases, I have read the assessment orders. It specifically says the assessee has given shared some right with the Indian company, my lord. In joint venture, they have sold the property. Say after, but here in not.
Like this, 1 copy is being multiplied.
Yes, my lord.
It is a royalty,
Yes, my lord.
something like that.
And also, if any addition is made by the Indian company, they joint venture, they sell the software, my
Can
lord.
have it on 13th.
Yes, my lord.
We'll dispense with, we'll have it on 13th. If they-
Please, my lord.
The very same SC's matter is listed on the weekend.
The same SSC on the same point. Oh, this is the same order. Then we'll have it on 13th.
Please, my lord.
Just say this, though Mr. Sanmati states that the filing of the written submissions be dispensed with till the final hearing,
Yes, my lord.
we have been informed by the counsel for the respondent that identical issue arising from the common order with regard to the same SSC is listed on 13th of January. If that be so, re-notify on 13th January.
Please, my lord.
Serial number 12. Srinivas.
Yes,
I filed the last time at the honorable court directed me to
yes,
produce the
what do you say
documents
on this?
which have been relied upon, and I have produced minute.
What have you filed?
Minutes
What have you filed?
on Friday I have filed.
What did you file?
And I have filed the exhibits to show that the property in question falls within the municipal limits. And the second document is the guided value of the sub-registrar, wherein what is the rate of the property.
But you don't file these documents there. Why did you file these documents there?
Yes, minutes.
But why come to paragraph 12?
But that is not reflected in the order minutes. That was not reflected in the order.
But no, but there is a finding against you on this. Just see paragraph 12.
But on the other hand, the defendant number 2 to 4 have taken contention that the compensation awarded by the defendant number 1 is very meager, as the value of the property was more than 1,000 rupees per square feet. In order to prove the said fact, defendant number 2 to have not produced the substantial documents or evidence to show that the value of the property is more than 1,000 square feet. In this behalf, the contention taken by so and so appearing for the defendant number 2, 4 is not tenable. If at all they are entitled for the higher rate of compensation, they are at a liberty to work out.
How much was your claim for?
Minute.
How much was your claim for?
Minute, the
Show us
sub-registrar's
document.
guided value was 660 rupees minutes.
How much has been granted by the land acquisition?
350 rupees per square feet minute. First, at the first instance.
350, the second authority.
No, second, thereafter I filed appeal before the DC. DC minute, the enhanced to 600 rupees per square feet.
Now, where are the documents which you have now relied on?
Minutes, along with the memo I have filed minutes. Minute, my lords would kindly turn to page number 15.
15.
15, please. Minute, where minute the annexures have produced or stated. Minute, exhibit P1 is the notice from so and so. Relevant would be minute, exhibit P9. Evaluation certificate. Exhibit P10 is the evaluation certificate issued by the sub-registrar. And exhibit P12 to 16 are the approved plan. And exhibit P17 would be the endorsement regarding change of kata, and the exhibit meet 19 to 24 are the rent agreements. Minute, I have produced the same. Minute, my lords would find it at page number 19, the sanction plan by the municipal authorities.
But how does that denote what is the land value?
My I'll come. May I request your lordship to kindly turn to page number 54, please, minutes.
Of this?
Yes, minute. Exhibit P10, it would be. It is in Kannada. Minute, I have said it is the guidance 30. Next page, minute, I have extracted what it is. Minute, it is the guidance value. 99, 2000, minute, they show the for residential property, 290 rupees per square feet was the prevailing rate. Minute, for the commercial, please, minutes, it was 660.
So, guidance value for the year 95 to 2003, 4.
Please, minute.
When was the land acquired?
Minute, it was 3/11/2000, minute, notified on 3/11/2000.
2000 is 660.
Yes, please, minutes.
So, how much he got?
Minute, 350 has been granted. Minute.
This is what? This is, yours is commercial or residential?
Commercial property.
So 660 is the
Yes,
guidance
minute.
value.
Minute, they have taken 350 minutes.
Pardon?
The tribunal has granted 350 rupees per square feet.
But did you produce this before the tribunal?
Please, minute, it was subject matter in the arbitration suit, minute,
Oh,
73 of 2007.
okay. The tribunals gives you. No, come to paragraph 5. It has been granted, 600 has been granted.
Thereafter, it was reduced, minute, on the appeal filed by the.
Oh, before the learned.
Please, minutes. At first instance, minute 50, thereafter, minute, the DC arbitrator.
That he could not have done it. That he could not have done it. No, this possibly you are right. You could not have reduced it. But where does it say 300? Where does he reduce it to 350? Again, on hearing the word defendant and arbitrator pass the award, awarding company. After hearing both the sides, my Honor President dismissed the appeal and allowed the appeal. According the matter was remanded back to the Deputy Commissioner of First Disposal. Again on hearing. Notice issued on this one?
Sir.
Yes, sure. Who appears?
Well,
Okay.
as for
Who appears for the respondent NHAI?
I appear for respondent, number 2 NHAI.
Yes, what do you say?
I'll submit, I was under the impression today that the matter is listed for hearing on IA for bringing the LRs on record. With regards to the merits of the matter, my lords, I have certain judgments to put before the Honorable Court. With regards to the
Let's see the IA, ma'am.
it's for the bringing the LRs on record for condonation of delay to bring the LRs on record.
Now, where is your application for LRs?
I had filed it.
And the copy of those IAs has not been supplied to us, so I was under that impression, my lords.
Right, it was sent by the registrar. Yes. Even the list of documents which have been filed, my lord, memo also has been sent on the RPAD.
You have 701 days delay.
And what happened was that there was, after Malad, after demise Malad, he started an industry, Malad. He fully, Malad,
We'll keep this
he
document
went bankrupt, Malad. And thereafter, Malad, he had to carry, thereafter, Malad.
No, just 1 minute. Just say this. You file reply to these applications.
My lords, I will.
Where is your application for LRs? Just say this, IA 1 of 24, 2 of 24, 3 of 24. Comma, are the applications seeking condonation of delay, setting aside of abatement, and for bringing the LRs on record. Full stop. And the counsel for the respondent number 2 seeks and is allowed 3 weeks to file reply to the applications. Re-notify all. Let him file. A huge delay.
My lords.
27th January, sir.
Grateful, my lords.
Great.
Serial number 13. Sanmati.
There was issue of transfer pricing, my lords. Other side is not, I'll take a notice on the other side, my lords. Because there's not, no one's representing them. We also.
Just say issue notice on the appeal as well as the application seeking condonation of delay. Returnable on.
27th January. 14 and 15 urgent. 16.
Well, 16, my lords, the matter stands covered. But matter can be disposed of, my lords. In fact, the same assessee, my lords, have gone through it.
He's saying it is covered in your favor. Pardon? Forget it. You are, who is the counsel?
Let his name be reflected, my lords.
Pardon?
Let his name be reflected, my lords. Let Mr. Balram's name be reflected for assessee, my lords.
So how would we do that?
Yes.
Once, ultimately, I don't think now you are Mr. Tiwari, you are saying so it is. You do one thing, you get your memo of appearance. That also we can take it during the course. Get it by lunchtime. Signed by Mr. Balram. So that we can record his appearance. Yes. Don't file it, just give it to the court officer. This appeal arises from an order passed by the ITAT. Dated 25/5/2022. Mr. Tiwari, just check the facts, huh? 25/5/22. In income tax appeal number 613 of 2000, no,
Yes, my lords.
in appeal number would be all these appeals.
Yes, my lords. What 620, 613 has been disposed of, my lord. 620 is what matters come up today, because matters stands covered.
This arises from which one? Which ITA?
620, my lords, the one that is here right now.
This one. First item.
6?
One minute.
No, you see the impugned order at
This one. Four.
No, 495. My cost title is page 2.
495,
my lords.
490. Rises from ITA number 495/Bangalore/2020. Whereby the ITAT has has allowed the appeals.
Dismissed.
No. Which this 495 was filed by whom?
By the assessing, my lords.
By the SSC, has allowed the appeal filed by the SSC. And that's right. Pertaining to the assessment year 2016-17, that's right?
Yes, my lords.
By stating in paragraph which page is that? 50.
Page 2, my lords, cost title. Cost till page 2, my lords. The order, my lords, at page 56, the operative part, my lords.
Is it 56? It stops at 50.
Forty-seven, 48. Tribunal order, my lords, the operative portion is at page 50. Ends at page 50, my lords, page
15, huh?
yes, my lords, 56.
Whereby the tribunal has allowed, only one ground has been allowed.
Yes, my lords. My lords, that, my lords, is page 43, my lords, at page 43. Sorry, my lords, page 47, internal page 43 or 46, page 47.
Page 47.
Notional amount.
No. Has allowed the appeal by stating in paragraph 10.
Page 20. Page 20.
What is this, Mr. Sanmati? Come to page 47.
Yes, ma'am.
We are assessment year is 15 and 16.
Yes, ma'am.
We are concerned with 16, 17.
16, 17, my lord. Your lordship, arising out of.
Issues ground one, they sum up.
Yes, ma'am.
Are we concerned with this?
Yes, your lordship, the arising, the connected matter, my lord, filed along with this appeal in respect of the other assessment year arising out of the common order.
This one.
Yes, my lord, arising out of the common order.
But whereby the ITAT has allowed the appeal in favor of the SSC.
Yes, my lord.
That's right.
Yes,
That
ma'am.
would be sufficient, na?
Yes, my lord, that is sufficient.
Mr. Tiwari and Mr. Sanmati, who appeared both?
Both, my lords.
Mr. Tiwari, Mr. Sanmati and Mr. Tiwari states that the issue in hand is covered by in favor of the SSC in terms of order dated 23rd September 24. Passed in income tax appeal number 613/2023. Arising from the same impugned judgment for the assessment year 2015-16. Full stop. The order passed by this court in ITH 613 of 2023, dated 23rd September 2024, reads as under. Just say paragraph 3, na?
Yes, my lord.
Paragraph 3, 4, and 5 of the order reads as under. For parity of reasons, in view of the submission made by Mr. Sanmati and Mr. Tiwari, the appeal is dismissed at the stage of admission, answering the substantial question of law against the appellant's revenue and in favor of the respondent SSC. We have dismissed, we will say like this, substantial question, in the other matters.
Lordship, just on submission, my lord, instead of saying the revenue council, my lord, your lordship can say the assessee council, my lord. Sometimes the department will take a fair submission.
Okay, just say this. We don't say Mr. Sanmati, Mr. Tiwari, just say that the maybe Mr. Balram, we have to act. Where is he? Just call him. So that at least physical presence must be there. Just say this, Mr. Balram appears for the SSC, states that the present appeal is covered in favor of the SSC against the revenue, most particularly in view of the order passed by this court in ITA number 613 of 2023, which was decided on 23rd September 2024.
And he has also appeared in that case. He has appeared in that. Balram only appeared.
Yeah. Mr. Sanmati appearing for the appellant revenue, Mr. Sanmati and Mr. Tiwari appearing for the appellant revenue. Appellant's revenue are not in a position to dispute the aforesaid submission of Mr. Balaram.
I'm sorry, my lord. Sometimes fairness will cost us, my lord. Sometimes in the fairness will cost us, my lord. Therefore.
Happens. Yes, then same in view of the above, appeal is dismissed. Remove the first one, where we have said, Mr. Sanmati, just remove that. Now it will be only this. Here, you can follow this order. Call Mr. Balaram and file your memo of appearance. He should be here at 2:30, 2:35. Okay, yes, ma'am, next. Delay is 333 days.
Yes, ma'am.
Was condoned there in the other matter.
Your lordship,
Yes,
it
show us,
was
ma'am.
just-
No, it is not, my lords. It's silent, my lords.
The same, one question only, substantial.
One question also in that case, my lord.
Ma'am. In this case, so you will change substantial question. You will frame it. You will see the memorandum. This one. This one. But though there was no IA, it appears in this
No, my
condonation
lord,
of
it will be there in the order sheet, my lord. Both the appeals were filed at the same time, my lord.
must have been condoned.
Yes, my lord.
So I don't-
Just check up. We will see. It will follow for parity
Same
or
order,
is
ma'am.
it there also? Huh?
The same order, whatever is posted in the.
Just
connected-
check up this, ma'am. Is IA there? Check up. Just check up same order. In IA also same order, ma'am. Okay. Next, 17. What is this?
My lords, there's a matters coming first time. I have to take notice on them, my lords.
Why? How do you explain the delay?
Has to go.
Notice has to go, my lords. Matters first coming up.
Issue notice both on appeal and delay application.
27th January. Serial number 18. 18.
There's a delay of 129 days, my lords. The issue of transfer pricing is involved, my lords.
Transfer pricing. Will condone the delay. Just say this is an application seeking condonation of 129 days delay in filing the appeal for the reasons stated in the affidavit in support of the application seeking condonation of delay. And the learned counsel has left it to the court to decide the same. We condone the delay of 129 days in filing the appeal. The application disposed. The affidavit is there now in support.
Yes, sir.
Now, just say this, admit the following substantial questions of law arises for consideration in this appeal. To stop, as a coordinate bench of this court is hearing an appeal regarding the transfer pricing, which is the issue in this case, as in this appeal as well. List the appeal in due course to await the outcome of the said appeal.
19,
Plus issue of transfer pricing, my lords, but the delay of 38 days, my lords. They've also not been served yet, my lords. I'll take up notice, my lords.
Just say this, issue notice on the appeal as well as application seeking condonation.
27-1. Serial number 20,
It's 20 to 23, my lords, all coming out of the same assessee, my lords. I'll take out notice, my lords. Because there's a delay is also substantial, 470 days.
Issue notice both on appeal and the application for condonation of delay. What about 24?
I'll file a better affidavit, bros. For matters coming first time, I'll issue notice on that.
20 to 23 notice would go. 24,
24 also.
Mr. Tiwari seeks and is allowed 2 weeks to file an additional affidavit to explain the delay of 457 days in filing the appeal.
27-1. Serial number 25,
There is delay of 51 days, my lord. I will serve it.
Give him a call. You have any serious issue on 51 days? You look into it. Just re-notify it on 16 December.
16. Serial number 26, Suresh, 26.
Lordship, appearing for the appellant in this matter. The matter is put on for continuation of delay of 90 days, your lordships. However, we've received a copy of the order, certified copy of the order only on 23/7, your lordships. If I may be allowed to file an affidavit, additional affidavit, attaching the postal receipts, because we didn't get the postal receipts during filing.
No, when did you file the appeal?
We filed it on 29th of November, your lordships.
So you're barred by time.
Your lordships, 90 days, if the order of, your lordship, the impugned order is dated 3/5. We received it on 29/11. Sorry, we received it on 23/7.
23/7.
Yes, your lordship.
So how much is the delay even otherwise?
Otherwise, it is 8 days of delay, your lordships.
Just say that learned counsel for the appellant seeks and is allowed 2 weeks to file an additional affidavit
I will,
in support of the application seeking condonation of delay.
I will file it, your lordships.
Just give the date. please.
27th January,
Notice may be issued, your lordship.
An application.
serial number 27. 27,
Lordship, I may be permitted to take out notice, my lord.
Issue notice both on appeal and application.
27th January, 28,
In this case also, my lord.
Same order, ma'am. Issue notice.
27th January, 29,
How would you say this?
29,
Lordship, 29, my lord, it's a covered matter, my lord.
Covered.
Covered. So Lordship, the tribunal has followed the decision of this honorable court, my lord. So Lordship may kindly turn to page number 9, my lord.
What do you say?
So page number 9, my lord, paragraph number 4, my lord. Decision of this honorable court, my lord, in the last 4 lines from the below, my lord, reported in 385 ITR 346, my lord.
Just 1 minute, please. Which page you said?
Your lordship, the decision is quoted in page number 9, my lord, paragraph number 4, down below.
Just
last-
show the file, it's not opening.
Page 9, my lord, paragraph 4.
This is ITR what, 346?
385 of, ITR 385, my lord, 346, my lord. The finding is at page number 14, para 9, my lord. In assessee's own case for other assessment years, my lord, this honorable court has held against revenue, my lord.
Just say this, the present appeal has been filed challenging the order dated 18/3/2021 passed by the Income Tax Appellate Tribunal. Now, in which appeal this appeal has been filed?
Your lordship, this appeal has been.
326.
Yes, my lord. It is 327 Bangalore 2018, my lord.
It's only in 327, now,
327, my lord.
whereby the ITAT has decided 2 appeals, 2 cross appeals filed by the parties herein. First, the challenge in this appeal by the revenue is in ITA number 327 oblique. That's right, Mr.
Yes, my
Sanmati?
lord.
Oblique bank,
Your
oblique
lordship, the
2018.
next matter is connected also, my lord. The same judge. The next matter, my lord, the seal number 30, my lord. That is connected matter. IPS
30 is the different, the other appeal.
Yes, my lord. Other appeal, my lord. The 727 of.
Will pass separately.
A
or we
separate
can-
order may be passed.
In Bank 218 assessment year 2007-2008. Which appeal has been allowed in favor of the SSE by the ITAT following the judgment of this court in dated 28/4/2016, reported as 2016 bracket 385 ITR 346. First, paragraph 9 of the impugned, paragraph 9 and 10 of the impugned order reads as under. First, the substantial question of law raised by the appellant revenue all questions.
Your lordship, all questions, my lord, but issue is only one, my lord. The question is, my lord, whether the assessing authority in consequence to a search conducted in some case, my lord, in the absence of any incriminating material found during the course of such, whether assessment order can be passed under section 153C. This honorable court held that if there is no incriminating material, this assessment cannot be passed.
No, but this 1, 2, 3 deals with those incriminating material.
Yes, my lord. It is all question. Same, my lord. 1, 2, 3, 4. I have raised 4 questions, but the issue is one only, my lord.
First, though, just say this, though the appeal raises the following substantial questions of law. Mr. Sanmati states that in substance,
Yes, my lord.
the substantial question of law is whether there whether section 153C
Yes, my lord.
of the act could be invoked when no incriminating material
Yes, my lord.
incriminating material found during the search,
Yes, my lord.
found during the search. Since the issue, Mr. Just say Sanmati, do not dispute, do not contest that the issue in hand is covered by the judgment of this court reported in 2016 385 ITR 346, which aspect has been noted by the tribunal in paragraph 9 and 10, comma, for parity of reasons, comma, we dismiss the appeal by answering the substantial questions of law against the appellant's revenue and in favor of the respondent SSE. That's right?
Yes, my lord.
Next. Okay, clear now? Here, this 9 and 10 you will see here. Page 15. Page 16. You relied only on 9 and 10, na, paragraphs?
Yes, my lord.
Next, this also.
This is for the other assessment here, my lord. Another.
Oh, this is the same as, now where is the, this is other assessment here?
The same impugned order, my lord. This is for the assessment year 2008.
Issue is not different.
No, same issue, my lord. Common order, my lord.
Common order. Why don't we pass a common order only? Substantial questions of law, same.
Your lordship can.
Everything, ma'am, just show us this thing. The second one. This is the second one, item 30.
That is 29, sir.
Where is item 30? Let's see the questions of law.
Yes, ma'am. The same questions, ma'am.
Same questions?
Questions.
Don't make it two. The first paragraph will be, we have changed the challenge is to the IT-80 order. We have said in appeal number 326, 327, make it 326 also. Make it 326 also. Of 2000. Okay. Then we have said that that appeal has been filed by the SSC, na? No, say both the appeals. Just say na both the appeals. In this. Both the appeals, we have said na both the appeals have been decided in favor of the SSC. Though the assessment years are different, comma, the IT-80 has relied upon that judgment, na, ITR. And we have reproduced paragraph 9 and 10. We have reproduced substantial questions of law also, no? Everything also. Okay. Next,
31.
There is still of 105 days, my lord.
issue notice on this.
Yes, ma'am.
Issue notice.
3rd of February.
We'll just come back in 10 minutes. We'll just come back.
This is 89 days. Injectment is from 22.
That's why.
For my case, there is no application. You can have challenge the 133, this one, 133.
Courtmaster, ma'am.
Madam, on 10 minutes, court will resume, madam.
Okay, ma'am.
Yes, ma'am.
Serial number 32, Your Lordship. There is a delay of 394 days, Your Lordship. The notice of the tribunal for the hearing and even the order also was directly communicated to the auditor, Your Lordship, which was not intimated to the appellant, Your Lordship. That caused the delay, Your Lordship. He was not aware of passing the order of the tribunal and even at the hearing stage also, Your Lordship. Serial number 32.
Just say notice, Mr. Sanmati accept notice both on appeal and application under condonation of delay. Reply, if any, to the application be filed within 2 weeks. List on.
27th of January. Much obliged, Your Lordship.
We can. Yes, we'll just pass over. This is a parted matter, no?
Please, Manoj, I appear for the respondent in this matter.
Yeah, we'll just pass over, ma'am. We'll take it up.
Please, ma'am.
34, Sanmati. 34.
The identical issue is pending before the Honorable Supreme Court, my lord. It may be adjourned for some time.
Tony Erickson.
Yes, my lord.
That essentially, but I cannot dispute the fact that Tony Erickson itself
Is under consideration. We'll just simply re-notify it.
Yes, my lord.
Just re-notify it. We'll have it end of January.
Yes.
End of January or February, first week also.
3rd of February, sir.
Please, my lord.
35. Serial number 35.
Hmm? You take notice. Issue notice, so and so accept notice for the respondent. List the appeal for hearing on.
3rd of February.
Get a copy. That's the, just say 13 January.
15th January.
You have the copy of the appeal. Let a copy of the appeal
Yes.
be given to the counsel appearing for the respondent. During the course of the day. You have copy, Mr. Sanmati?
Please, my lord. I will share the copy, my lord.
36, government took it. 36.
What is this, Mr. Bhatt?
This is a matter where the provisions of section 17 and rule 131 have been misappreciated by the tribunal below. I must point out one thing, my lords, before I start, that the office note says there is no delay, but prima facie there looks like there is a delay. I'm not able to, had it been 10 days here or there, I would have doubted my calculation. This is a March 2021 order, and the revision petition is filed in October 2024. I'm not able to, there is no place for me to hide.
My lords, may I submit?
Yes.
Would like to take notice on behalf of the respondents because I have appeared before the tribunal. And I agree with Mr. Bhatt saying that there is a delay. And that's what even I wanted to point out on.
Objection. But do you have any issue? Whatever is the delay?
Oh, the delay is more than 2 years. So let a notice be issued.
Oh.
I have no problem about
No,
admission, but
then
later
you
on,
must
let
file
us.
your affidavit supporting delay.
There is
They have already filed.
It's filed. I'll see if there is if there is any lucky not to be filled,
No,
but
where
there
is
is a
the-
detailed
no.
affidavit filed.
1 minute. Where is the affidavit in support of your delay?
Now, what has happened is, there is an application,
Okay, you have filed it.
application is
But
filed.
why
along
this,
with
why
an
this application not reflected in the region?
My lord, what has happened is this.
Oh, you said not pressed.
No, and
Then you will suffer the consequence, Mr. Bhatt.
no, my lord, that is the conundrum. When I received the office objections, one of the objections reads IA for condonation of delay filed. To be clarified, since petition is in time, IA for CD may not be maintainable. And then the section without, in my respectful submission, without any application of mine, appears to have said not pressed. I, persuaded by the, but I can't bring myself to go on this line, man. It,
Just say this.
that application may have to be revived.
Yes, one, that's what we are doing.
I'm grateful.
Mr. Butt states that, Mr. Butt states apparently the appeal filed, both the appeals, no?
My lords, 36 and
Both the
37.
appeals filed by the appellant herein are barred by time. And in fact, applications have been filed along with the appeal seeking condonation of delay of how many days?
My lords, the time limit is 180 days, my lord. I have.
It's a blank, your days.
They have to calculate the days, my lords.
Approximately, I will make the calculation, Lord, approximately 2 years.
Application has been filed seeking condonation of delay. We find from the prayer clause, the same does not depict the number of days by which the appeals are barred by time. Mr. Full stop. In fact, Mr. Butt also points out, it's only on the asking of the registry that the appeal is not within, is within time, that the appellants herein have not pressed that application. Full stop. The submission of Mr. Butt is also acknowledged by the counsel appearing for the respondent, who states that the appeal has been filed after almost 2 years. If that be so, we revive the application for condonation of delay. The registry shall number the said application. Full stop. Mr. Full stop. And accordingly issue notice both on the appeal and on the application seeking condonation of delay. Yeah, do one thing, just cut the last sentence, notice. Mr. Butt shall also fill in the blanks which appear in the prayer clause seeking condonation of delay within 1 week from today, and serve the copy of the appeal along with both the application for stay and also the application seeking condonation of delay on the counsel appearing for the respondent. Who the counsel for the respondent shall be at liberty to file a response to the application seeking condonation of delay. Okay, within 2 weeks thereafter. List both the appeals for hearing on.
After vacation.
We'll give you a date,
27th January.
27 January.
I'm
Yes.
deeply obliged.
38. Serial number 38.
Just say issue notice, so and so accept notice. Copy of the appeal paper would be given to her during the course of the day. You
Yes,
have
my lord, I have given.
a copy of the appeal has been given to the counsel for the respondent. List the appeal for hearing on.
3rd of February. Serial number 39.
My lords, appearing for the appellant in this matter, my lords. My lords,
Yes,
and record has some personal inconveniences traveling today. And further, my lords, in the last occasion, your lordship had mentioned saying that the department appeal on the same impugned order had to be listed along with this appeal, which has not been listed today, my lords.
Please, there is, well, it's against the learned single judge, this is ordered, even we filed a writ appeal. Writ appeal
when is that listed?
date is not given in that.
You should move a memo, na, Mr. Dilip.
It's last date, your lordship said.
We'll just say possible, just 1 minute. Did we say so? It should be listed.
It's not come in the order sheet, my lords, but
Just show us. Just say this, we have been informed that even the respondent revenue has filed an appeal challenging the order of the learned single judge. Order of the learned single judge dated 3rd March 2023 in writ petition number 21146 of 2019, being writ appeal number
960 of 2023.
If that be so, subject to the orders of the Honorable the Chief Justice, the said appeal shall also be listed along with this appeal. Full stop. Just say re-notify on.
27th January,
Grateful, my lord.
serial number 40. Neeralgi 40.
Just pass over.
41 urgent. 42.
See, possibly I'll place it before another bench.
My lord said some other matter also,
Yeah.
perhaps expressed some difficulty therefore.
Just subject to orders of the Honorable the Chief Justice. We'll do one thing, we'll have it in January, Mr. Just say that be listed before another bench, subject to the orders of the Honorable the Chief Justice on. Just give a date in Jan, which is that date, Mr. Suna?
In the other matter, your lordships are not given a date. Your lordships had directed it to be.
Different matter, just give any date.
13th January, sir.
Well,
Serial number 43.
My lords, I appear for the respondents. If my lords will kindly see the last order sheet, permission was given to me for filing synopsis. I have filed it on record.
Your Lordship, he has served this copy of synopsis, my lord. Your Lordship, the tribunal has followed its earlier order. In earlier order was challenged before this honorable court, my lord, we had filed appeal. Your Lordship, this honorable court that it's not maintainable because as per the jurisdiction, it has to have to file appeal before the honorable Gujarat High Court, my lord. Your Lordship, I have to verify it, my lord, whether subsequently, whether we have filed the appeals before the Gujarat High Court, my lord. I want some time, my lord.
Lords will kindly see, on the last occasion I pointed out that the amendment to the pleading is carried out in a half-hearted way. Only the prayer has been done. Substantial questions of law were got framed in October 2020 without showing the impugned order. Even today, the impugned order has not been placed before my lords.
No.
The pleadings are halfway because the impugned order is now 42 of.
Along the amended application. Along the amended application.
The impugned order is something else which was 6 months earlier. Continuation of delay application is not there. They have to verify whether they have gone to Gujarat High Court, but still they want to pursue this. This is the 5th year. The asset has become part of the block. Nothing survives.
Your Lordship, I have not sought for stay. There is no urgency for the SSC.
We'll have it, let him take instruction, Mr. Rao.
My lords, kindly, I have no problem. Kindly only see the record, the proceeding sheet record. My lord. For last 4 years, I have been subjected to this umpteen number of times. This is the 13th or 14th hearing. 14th hearing.
2020 matter, Mr.
Your Lordship, last finally, my lord, after vacation, it may be taken. I will get the instructions.
Have it on opening 6th of January, take your instruction, otherwise we'll hear the matter.
Please.
What
Your
happened?
second
Can
week,
you
second week
get
of
it?
January, my lord, second week.
You get it before that, before the vacation starts.
Yes, my lord. No, my lord, after vacation, my lord.
Oh, as a last opportunity on the request of Mr. Sanmati to take instructions as to whether the judgment passed by the Gujarat High Court.
No, my lord, whether we have filed appeal before the Gujarat High Court on the impugned order in relating to the other assessment year. Against the impugned order, we were.
Instructions as to whether any appeal has been filed before the Gujarat High Court with regard to a different assessment
Yes,
year
my lord.
in respect to the same SSC.
Yes, my lord.
In respect to the same.
May
SSC.
I say 1 second? Kindly
Yes.
have my synopsis. Against that year, they filed an appeal before Karnataka High Court. Karnataka High Court dismissed it and they told them to go to
Your
Gujarat High
Lordship,
Court
this
4
honorable
years
court,
back.
this honorable court held that it is not maintainable before this honorable court because assessing authority as well as the ITATs of Ahmedabad, you go before that court.
And that was 4 years back.
No, but he says in view of the judgment of the Supreme Court, not Justice Bhatt's judgment.
Yes, my lord.
It
My
will be
lord,
there only.
not because of that, my lord. That was much later. This was 4 years back. Kindly see the record. I filed
Now,
that for,
now
in my
tell
synopsis. I
us, Mr.
filed it.
Rao,
My lords.
tell us, Mr. Rao,
My lords.
now it's a different assessment year with the same SSC.
Yes, my lords.
Was it filed here in this court? Yes.
Yes, my lord.
Your Lordship, at that time, my
And
lord,
I gave the High Court order also. Kindly have my synopsis. The High
Your
Court
Lordship,
order is also given.
In that assessment here, the assessee address and as well as the assessing authority was of Gujarat, ITAT also Gujarat. But here in subsequently, it has been changed. It has come to Bangalore.
You're not understanding.
Yes, ma'am.
Against that assessment here, which
Yes,
you
ma'am.
are referring to,
Yes, ma'am.
you have filed an appeal here.
Yes, Mr. I had filed the appeal before this honorable court. Your Lordship, this honorable court not dispose of the matter. Page number 48 of the synopsis filed by the assessee, my lord, in ITA number 443 of 2019. Page number 48, my lord. Paragraph number 3, my lord. And this honorable court disposed of the matter, giving liberty to approach the jurisdictional high court, my lord. After this, my lord, I have to verify whether the appeal has been filed. If it is so, whether what is the status?
Kindly see the date of the High Court order, my lord. January 16, 2020. 5 years are getting over now.
Your Lordship now only has filed this synopsis, my lord. I will verify it, my lord.
Okay. Yes, we'll have it in the second week of January, Mr. Rao.
My lords.
Just have it on second week of January.
Yes,
13th January. Serial number 44. Sanmati.
Your Lordship, in this case, my lord, I have stated the tax effect as rupees 48 crores 56 lakhs 75,503 at page number 5, my lord. The amicus curiae has pointed out that, my lord, the tax effect is
We
less
noted-
than.
Yes, that's what we have noted on the last day. So the order,
Your Lordship may kindly turn to the.
did you check up this?
I have not received any instructions, my lord, but your Lordship may kindly disallowance made by the assessing authority, my lord, it is false less than 2 crores, my lord. Page number 29, my lord.
Check up now, Mr.
Yes, ma'am.
Sanmati. Not Mehndi, just, which page is that?
Your Lordship, page number 28 is the assessment order, my lord. The disallowance made, my lord, at page number 29. Two disallowances made under section 10AA as well as section 14A, my lord.
Oh, 3 crores 74.
3 crores 74 lakhs and another one 10AA is 28 lakh 7,038.
So,
If 30% is seen, my lord, it is less than 2 crores, my lord.
so how would you answer them?
Your Lordship, the disallowance comes to, tax effect comes to less than 2 crores, my lord. But here it is have stated at 48 crores, my lord. We'll just, in the appeal memo, my lord, because said, your Lordship, the entire assessment order has been set aside by,
How can that be 48 crores?
and the demand rise is also 1 crore, my lord, in page number 29. I cannot say
Figures.
48.
Oh,
Well, Lordship, maybe I have taken this amount, my lord, page number 29, total tax payable as per book profit 47 crores. That might have been the reason for stating this
but
amount.
will this figure have a bearing on the maintainability? Net effect?
No, my lord,
It would not.
it will not. Off the record, I will say, my lord, it will not, my lord.
Then what follows?
Lordship may record my submission that I rely upon this amount as per the page number 29, this tax
Do
amount.
one thing, we'll have it tomorrow. Take final instructions from,
Next week, my lord, Monday.
okay, list on Monday.
Please, my lord.
But tell us, other than Monday, you are at ITAT, all of you?
No, my lord, writ petition in.
Okay, oh, single judge, okay.
Yes, Because within one day, I am not sure whether I will get the input, my lord. Therefore, I sought one
Take
week.
instruction, we'll have,
Yes,
it.
ma'am.
It's a matter of 1 week only, take
Please,
instruction.
ma'am.
Be clear on that, so that
Yes,
we
ma'am.
record your submission. Next,
Please, ma'am.
Steam tool, sir. Serial number 45, Shri Mahesh Chaudhary.
My lord, appearing for appellant, my lord.
yes, ma'am.
My lord, seeking for short accommodation, my lord. Senior is not available today. A short date may be given.
My lord, even we have to produce the search records, my lord. My lord, in this case, my lord, learned single judge. He has held, my lord, that there was sufficient material on record to record the satisfaction for search. After verifying the search records. Now, my lord, we'll have to produce we were asked to produce the search records, my lord. A date may be given, my lord, next week or after vacation.
Did we ask that? To record? We asked for that.
Please.
Just say, request for adjournment is made by the counsel for the appellant. Even the counsel for the respondent states the record as directed to be produced shall be produced on the next date of hearing. We notify all.
13th January. Serial
Obligement.
46, Sushal Tiwari. 46.
I'm ready, my lord.
Huh?
I can start, my lords. I can start, my lords. I will start, my lords.
What is the issue?
Issue is about 263, my lords. The revision power of the Principal Commissioner of Income Tax to revise the order of the assessment officer. My lords, in what grounds can he do it? There are only two grounds, my lords: loss of revenue, prejudicial to the interest of the revenue, my lords. Now, based on that, my lords, we have to assess whether the order passed by the PCIT today under 263 is correct or not. Whether the view taken by the assessing officer, if at all, my lords, whether there was a view taken by the assessing officer is also subject matter of question, my lords.
Sweet. How long it would take from your side?
My lords, I have 5 judgments, my lords, that I have to show to my lords, my lords. That might take my support. My lords, I have also filed not.
Depends on what my learned friend says, but otherwise,
How many?
according to me,
How many are the next week? Yes.
My lords, may I come back after 10-15 minutes, my lords? Because I have pass over, my lords.
So then we'll take up one matter. There is a part at which we are hearing it. That will then we'll possibly have it post lunch.
Yes, my lords, post lunch.
post lunch. Great. Set this properly.
All the passwords.
Serial number 1, Shri Jagdish Nivaldi.
Yes, Mr. Kamath.
I appear for the respondent.
Lord, based on certain intelligence information that the Director General of GST Intelligence had received, Lord, we conducted search of the premises of a company called Raj Chemicals in Delhi. This company had been supplying goods, particularly chemicals, to various entities outside Delhi without actual supply of goods. In other words, it was engaged in bill trading. So we recorded a statement of the proprietor of that entity called Raj Chemicals. And he named several entities to whom he had supplied only invoices without any goods. And one of them was the writ petitioner.
File your submissions, no? On the last date. Not filed.
My lord, we have filed.
But
I think, okay, then they have not filed. Yes.
I have not prepared a synopsis, Lord, but a very short question, Lord.
Go ahead. They have filed it.
Yes. So this, the proprietor of Raj Chemicals, Lord, he disclosed that he was engaging in passing on invoices without there being actual supply of goods. And among the various entities that he named, one of them was the writ petitioner called Kesar Chemicals. Thereafter, we conducted a search of the principal business premises of the writ petitioner Kesar Chemicals. And we found that it was a vacant land. Although it was said to be a business place, it was a vacant land which was subjected to redevelopment in Mumbai. In Mumbai. Thereafter, there was an...
This Raj Chemicals is based where? Mumbai?
Delhi.
Okay.
Raj Chemicals is based in Delhi. We first conducted a search there and we recorded a statement of its proprietor. He disclosed various
Only invoices, no supply.
only invoices, no supply. Based on that, we searched the principal premises, business premises of the writ petitioner and found that it was an empty land. Then we went and searched their office premises. And then that was conducted on 29th of July, 29th of July 2021. It went until the next date, that is 30th of July. During these investigation proceedings, the proprietor one, Mr. Priyesh Shashikant, he recorded his statement and he conceded that yes, about 4 crore 88 lakh worth goods invoices have been received without there being actual. He said our arrangement was that Raj Chemicals will directly send it to our customer. We did not know whether he had actually sent or not. That was the statement that he gave. But when he pointed out that yes, you have received invoice, he said yes, there are no goods. I am liable to pay this 4 crore 88 lakh. At this point, my lord, would your lordship kindly have a look at section 74 of the CGST Act, which gives an opportunity to the dealer concerned to pay only 15% penalty. He will say, yes, this is my liability. I will pay only 15% penalty. Otherwise, if we lay our hands, we demand, then he'll have to pay 100%. Your lordship may have one look at that section 74 of the CGST Act.
15% penalty subject to filing appeal.
No. Well, I'll read it. It's a very short penalty. Please have a look at section 74. If he complies with that, that concludes. It's like a arrangement between the department and the party concerned. So please have a look at section 74. Determination of tax pertaining to period up to so-and-so, not paid, short paid or erroneously refunded, or input tax credit wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts. Number one, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input credit has been wrongly availed. Now, this is where we stand. Input credit has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been so paid or which has been so short paid, or to whom the refund has erroneously been made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with interest payable thereon under section 50 and a penalty equivalent to the tax specified in the notice. So if I send a notice, it will be the entire amount plus 100% penalty. Now please have a look at subsection 5.
Entire amount and
100% penalty.
over and above.
Over and above. Please now have a look at section 5, subsection 5. The person chargeable tax may, before service of notice under subsection 1, pay the amount of tax along with interest payable under section 50 and a penalty equivalent to 15%. I will add the word only because he'll pay only 15%. So he gets some sort of a...
Not 100% once you issue.
Yes. If I issue a notice, then it will be 100%. But before that, now in the search proceedings, he knows where he has gone wrong, what is his liability. So it's like an opportunity for him where he can concede and he can close the proceedings with only 15%. So he has a saving of about 75% of the... Mitigating. Except the so-and-so, subject to the condition that, of such tax on the basis of his own ascertainment of such tax or the tax as ascertained by the proper officer, and inform the officer in writing of such payment. Now, my lord, for these, we have rules. That is 142. The rules relevant to these will be rule 142. Lord, rule 142, notice and order for demand of amounts payable under the Act. Please direct attention to 1A, capital A. The proper officer may, before service of notice to the person chargeable with tax, interest and penalty under subsection 1 of section 73 or subsection 1 of section 4, as the case may be, communicate the details of any tax, interest and penalty as ascertained by the officer so-and-so, 2, where before service of notice or statement, the person chargeable with tax makes payment of the tax and interest in accordance with the provisions of subsection 5 of section 73, or as the case may be, tax, interest, penalty in accordance with the provisions of subsection 5 of section 74, or where any person makes payment of tax, interest, penalty, or any other amount due in accordance with the provisions of the Act, whether on his own ascertainment or as communicated by the proper officer under subrule 1A, he shall inform the officer of such payment in form GST DR 03 and an acknowledgement in form GST DR 04 shall be made available to the person through the common portal electronically. So what the rule says is that if a person decides to avail the procedure under subsection 5 of section 74, where he voluntarily pays, then he has to communicate to the officer by submitting form GST DRC 03. Now, the petitioner complied with that and he submitted DRC 03, which the writ petitioner has filed before the learned single judge, and I have produced it.
So what does it show? Does it show that he wants to comply with
Yes,
the
yes.
effect that he wants to
Yes.
compute the
My lord,
tax?
the issue in these proceedings are whether the payment was voluntary or not. That's all the simple question. I am saying it was voluntary payment before the single judge. My lord, I will go by the chain of facts as per the chronology.
So
My lord,
before-
please have a look at the.
Only Mr. Kamath, only before you issue notice, he has expressed himself.
Yes.
That's the point.
That, my lord, he doesn't dispute that. The writ petitioner doesn't dispute it.
Happened there.
Only he says it was not voluntary. I was coerced.
So he is ready to pay the 100% according to what is the effect thereof. No, have you issued notice?
Yes, I have issued notice now.
Now you have.
I have now issued notice. But my lord, please have a look at the writ appeal. There is one more additional compilation called, I'm sorry, in the written submissions filed by the respondent, a copy of the DRC 03 is produced. That your lordship will find at page number 113 in the written synopsis. It is in landscape. It is in landscape mode.
Yes.
Please have a look at that DRC 03. It says see rule 142.2 and 142.3, which I just read out to your lordship, titled as intimation of payment made voluntarily or made against the show cause notice or statement. I have not issued any show cause notice at that point of time. It is voluntary. Please have a look at clause number 3, serial number 3, cause of payment voluntary. So the writ petitioner, in terms of section 74 subsection 5, read with rule 142.2 and by submitting GST DRC 03 intimates me that it has voluntarily made a payment of 1.5 crore. Actually, there were two payments made. Page number 113.
That's equivalent to 15% penalty also.
No, they just made a part payment of 2.5 crore. My lord, the first, I'm sorry, I should have taken your lordship to page 113 first, 111 first. Page 111 is the first payment.
Yes.
This is on 31/7.
How much is this payment?
This is 1 crore. On 31/7, my lord, the search was concluded on 30th. The next day he deposits 1 crore. And then on 3rd of August, he pays another 1.5 crore. Totally, writ petitioner has deposited by submitting GST DRC 03, 2.5 crore. Now, whether according to him, this is the total amount or what, we do not know, but he has voluntarily paid this amount. Thereafter, my lord, after he made this payment, nothing really happens. On 2 dates, he makes the payment, first on 31/7, second on 3rd of August, 2018. Then the next event takes place in September, 16th of September 2021, when the writ petition is presented. In the writ petition, a purported affidavit is filed, which is dated 10th of August. And in the writ petition, he produces the affidavit clearly prepared under the instruction of a counsel, which is produced at page number 182 of the writ appeal. There, the writ petitioner disowns the statement. And for the first time, the writ petitioner says I was put under duress. He does not say so when he makes the voluntary payment on 31/7. He does not say so when he makes the voluntary payment on 3/8.
But we want to understand, if it is not voluntarily, he has not, then what follows? What follows? Then you are within your rights to issue show cause notice to him?
Yes, we have subsequently issued show cause notice.
There can be two eventualities.
Yes.
One, now what, at least whatever you have said. One, we have seen the provisions sections. If we, now what it contemplates is whatever is the liability plus 15% you will deposit.
Yes.
To obviate a situation where you would
Yes.
issue notice.
Yes.
To obviate such situation.
Yes.
It appears according to you, may not be, we will hear them, that it was whatever he has done at 111 and 113, depositing 2.5 crores, is in a step towards that.
Yes.
To mitigating it so
Yes.
that he can be
Yes.
through with that.
Yes.
We don't know that 2.5 crores is the complete amount.
True, because the writ petitioner was paying in installment. First, he paid 1 crore on 31/7, then he paid on 3/8. Then we thought he is going to make further payment and then let us know that this is the total payment according to him. As per the investigation, the amount of the fraudulent claim of input credit was 4 crore 88 lakh. So we were expecting, but in the meantime, he rushes to this honorable court. And please look at the prayer that he made before this learned single judge. The writ petition is produced along with my writ appeal, and the prayer can be found at page number 93.
But tell us one thing, Mr. Kama, this 2.4 crores, according to
2.5.
is according to is not the complete payment, even under that 15% stipulation.
Yes.
It is not.
Yes.
Otherwise, there was no question for you to issue a
Yes.
notice.
Yes.
There was no reason.
There
for
was
you
no
to
reason.
issue.
There was
If
no
he had satisfied that particular
Yes.
section,
Yes.
that's the end of it.
Yes. Please have a look at the prayer, my lord, in the writ petition at page 93, para 94. A writ of certiorari or any other declaring the investigation carried out under section 67 of the CGST Act by the respondent as blatant abuse of power, bad in law, excessive, illegal, and beyond jurisdiction. Consequently, to quash the summons to witness dated 31/7 issued under section 70 of the CGST Act. B. Declare that the recoveries to the tune of 2.5. Now, the writ petitioner, he claims it to be a recovery. Although he made the payment as voluntary payment, he characterizes it as a recovery. Declare that the recoveries to the tune of 2.5 crore, and he uses the word extracted coercively from the petitioner by the respondent at the premises on 31/7. No, this is also wrong. It was not at the premises. We concluded the investigation on 30th of July, and he goes back to from his office, he uploads. These are all uploading. He has to access the website and then make. On 31/7, we had no connection. He goes back to his office and then makes this payment. And later, at the office of the respondent on 1 and 2 on 3/8, at the time of attending to the summons, as blatant abuse of process of law. And third, my lord, please have a look at the third paragraph. Declaring that the payment coerced by the respondent, that the petitioner to the tune of almost 2.5 crore under so-and-so provision as illegal, bad in law, beyond jurisdiction. And fourth, quashing the statements forcefully taken by the respondent from the petitioner as illegal, since the claim was taken under coercion against the principles of natural justice, so-and-so, so-and-so. So lordship would notice that the premise on which the writ petition, the cause of action for the writ petition is built is that the statement and the payment were under coercion. Lordship will notice that in the prayer, that the dominant statement made by the writ petitioner is that the payment was made under coercion. Now, my lord, I entered appearance in the writ petition. I filed a detailed statement of objection, lord, which your lordship will see at page 308. And I specifically denied. My statement of objection begins at page 308. Page 308 in the writ appeal. And where I would like your lordships to kindly draw the attention is page 316 and para 15. Para 15, the respondent submit that the petitioner was not coerced to make any payment. The payment made by the petitioner was voluntary to the GST portal of the petitioner. search of the premises of so-and-so located at so-and-so was conducted on from 10:30 a.m. on 29th July to 23:30 p.m. on 30th July. The payment of 1 crore through form so-and-so on 31/7 was voluntarily done under so-and-so provision after culmination of the search proceedings voluntarily and was not coerced by the departmental officers, and the officers were not present at the premises when the voluntary payment was made. And also, my lord, one more paragraph at page 320, page 324, para 30, page 324, para 30. As regards the payment of tax made under made by the petitioners by form number so-and-so under rule number so-and-so, it may be noted that the particulars at serial number 3, cause of payment, it is shown as voluntary, and at serial number 4, section under which the voluntary payment is made, it is shown as section 74(5). And one final paragraph, page 325, para 33. The respondent submits that as contained in the preceding paragraph, the payment made by the petitioner was voluntary and the said payment did not take place at the premises of the respondent. Payment was made by the petitioner voluntarily on subsequent dates. Respondent specifically denied the allegation in this regard. The petitioner, having admitted to the act of tax evasion and offered the payment towards the tax and penalty, cannot be termed that the authority has coerced them. Such payment during the course of investigation is permissible under the provisions of CGST Act. The said payment will be considered while determining the tax liability of the petitioner at the stage of adjudication. Hence, there is no truth or substance in the said allegation. So before the single judge, my lord, the issue was whether duress is proved or not. Now, my lord, the principles of law as regards the legal, the duress is, the standard of proof is very, very high. There has to be clear and convincing evidence to demonstrate that there was duress. I can produce a whole lot of citations on that. The question is that by throwing all these principles to the wind, the learned single judge records a finding of fact that there was duress.
Why did you issue show cause notice on 30/11/2022? What was for what purpose?
No, by then he had filed the writ petition and it was clear that he is no more, he has abandoned that voluntary claim.
So then you invoke
I invoked 74.
74. Now, will that be the difference between what 2.5 crores he has filed and the larger amount?
Now we have forfeited the 2.5 crore. We will appropriate it towards the liabilities.
Towards the liabilities. So what we are asking is, so that will be adjusted and this notice is for the balance amount.
Yes. No. That notice cannot be characterized as for the balance amount. This is a notice under 74(5) where we will, 74(1), where we will adjudicate now.
You will adjudicate whatever is the liability, but there must be the liability defined under 74.
Yes, we have determined it as 4.88 crore.
That's the determination over.
Yes. In our new show cause. Okay. We have proposed to determine the liability at 4.88 crore. The writ petitioner is yet to respond.
That's the show cause notice.
Yes.
He has to respond.
If he responds, my lord, we'll determine and
what is the basis for the learned judge to hold it?
My lord, learned single judge, my lord, holds that there is duress on the basis of the affidavit which I have denied. Lord, that is something which he could not have done at all. The settled principles are serious disputed questions of fact cannot be gone into a writ petition.
Let's hear the counsel.
Should I read the provision, my lord, where learned single judge?
No, we got it. Ultimately, your case is only this. 74(1), 74(5), 74(1) would only be come into operation if 74(5) is not the benefit thereof is not taken by the SSC.
True, Lord. One other submission before that would be that the writ petitioner voluntarily made the payment under 74(5). Now he cannot wriggle out of it. The single judge could not have determined whether there was duress or not. He records a finding of fact that there was no duress, that there was duress.
But even still, we want to understand what follows. Let's put it this way. Very well. He said duress, I have given 2.5 crores. Very well. What is the effect? If it was not duress, you would not have issue given 2.5 crores. Then you were within your rights under 74(1).
Yes, precisely.
That's right.
That's my case.
But it is duress. Very well. Yes, ma'am. Tell us one thing.
My lord, may I?
Even if it is duress.
Because this appeal is full of narratives which are only to prejudice the case of the refund. Let me point out, my lord, very, very simple. Now they are saying investigation going on. Yes, I have replied. He says if he replies, I have given one box file reply in 22.
To the show cause
Yes, my lord, this is the,
of 3122.
yes, I have given reply. I'm still giving them each and every detail. The reason is Raj Chemical exists today also. He's carrying on business today also. He has given confirmation to me also, but that's the investigation part. The single judge, honorable single judge, has said, investigation, you must cooperate. In the first, I said, yes, I have no objection to. Only question before the honorable single bench and also before my lord is whether the payment, whether there was payment on own ascertainment by the SSC, by the respondent in this case. That is the only issue my lords have to decide. And for that, my lord, let me first point out the provisions which my friend halfway read. We must read the provisions fully. When it is alleged that you have made voluntarily, now I will explain the fact also which is explained in the petition also. They say you have gone to your office and made the payment on the next day. Why I could not make the payment on that day? My mobiles were seized by you. My mobile banks were shut. There was no OTP possible also at that time, my lord. And it was a peak pandemic season, peak pandemic. I was threatened with the arrest. These are all the facts recorded. I'm not saying something out of anything new.
Now,
So
what is the effect of learner single judge allowing the appeal?
The effect is, my lord, I will get the refund. My matter will go
So
on.
your refund of 2.5 crores.
Yes, I must get it. And it is supported.
And they will continue the determination under 74(1).
They can, my lord, if they find substance in the merit in the matter.
Your allegation is of coercion.
My lord,
Your allegation is of coercion.
100% coercion.
Where are the allegations in the writ petition?
My lord, they are. In fact, the writ petition is full of allegations.
Coercion on the part of which officer?
The visiting officer.
Where is the name? Where is the?
Name is given. My lord, we are given. May I? But before that, my lord, may I explain 74 because it is very important for my lords to understand. 74 requires my own ascertainment and my intimation. My friend, learned friend says it is in DRC 03 and acceptance by the officer in DRC 04. On the portal, there is no acceptance. There is no acceptance. And my lords asked a very pertinent question, whether your notice excludes that 2.5 crore. That is the main turning point, my lord. That is why I want to read, my lord, section 74, if my lord permit me.
We want to see the allegation in the writ petition.
Repeat. Okay.
There are the allegations of coercion. See, these are allegations akin malafide.
Yes.
Akin to These are sometimes something to say about malafide.
My lord, it is recorded in the order also, and I will point out in the petition also, my lord.
Writ petition.
They have attached, no? Okay, they have not.
This is the main, this is the.
One minute, my lord, I'll refer to because they have referred to my writ petition. Yes. My lord, give me a minute. Which is the thing, right? Yes. Now, Lordship, may see, I mean, from the beginning only, I may point out something. Intelligence officer visited, etc. Page 54 may be seen, man. Para 6, they have referred to Raj Chemical. After just showing the petitioner's statement of Raj Chemicals and did not provide any copy despite requesting the same. Raj is known, that is all right. Then, my lord, para 8. It was at that time investigation petition intimated Mr. Gupta of Raj has given a statement that they have not conducted business, just issued the invoice, etc., etc. So the petition was served, etc. Yes. And my lord, if my lords want my affidavit as the name of the officer also. The affidavit which I filed, which my friend says, I filed here also I've given. Let me give. Here also.
See para 13, see these has to be
13 onwards.
Now, who filed the affidavit on their behalf?
The proprietor. Proprietor filed. In their behalf.
No, on behalf of the appellants here. These need to be said so. You have said so. There are allegations in the writ petition.
My lords, yes.
But against whom? Which officer?
The visiting
Authorities?
officer. The visiting officer.
Who is the visiting officer? See your paragraph 13.
My lord, yes.
Behavior of the investigation authorities was initially polite. What are those initially?
May I, my lord, please give me a minute. I've given the name also in this. Lordship may see this. On page 58 may be seen. At 2:30 PM on 29, investigation authority took away 2 mobile phones. That is what I was referring to, my lord. That government is here.
This is your version. What is their version? And who would deposit their version? The officer concerned against whom allegations made. Now, who is the officer against whom the allegations made?
Well, let me check. The name is there in the affidavit. It is the persons present, my lord. May I request my lord to go to 182, my affidavit, my lord. The names are given in that. In the main, I have written only the officer from, just find the name. They should be. May I request my lord to go to page 182, which is the affidavit, my lords. The 5 persons who visited are given, my lord. Para 5. I was visited by investigation officer on 29/7 by the above mentioned so-and-so. In the morning, so-and-so, 5 officers visited. The main names were Haresh Katara. I only remember the surnames of the others. Then, my lord, on the
Was
next
this
day,
affidavit filed?
within 7 days, on the 10th August.
No. This was
My-
filed only the writ petition. It is not filed before any authorities.
Notarized.
It is presented only for the first time in the writ proceedings before the single judge.
Submission.
It is said to be dated 10th August, but it was filed only on 16th of September. It is
My
not
lord.
filed before any authorities.
My friend, I have heard him
Let us-
patiently.
No, 1 minute.
My lords.
Man, just tell us one thing. Was it part of the writ petition?
My lord, yes.
But why were these allegations not transposed in the writ petition?
Yes.
My lord, they were.
Where
My
are
lord,
the
they are-
allegations here? Blaming
Yeah,
the
they-
persons.
May I point out? My lord, it is there. My lord, give me 1 minute.
You may have said so. You have named the officers.
And complete mismatch.
My lord, the
between
names are
affidavit-
para 26, page 61 may be seen.
61.
There is respondent number 2, my lord.
No, but respondent number 2 is by designation. Who is that person? And these are the allegations, serious allegations.
And it's part of the affidavit.
We don't want to understand, we have not understood this. Why an affidavit along with the writ petition, but not those allegations in the writ petition?
They are there, my lord. May I read? My lord may permit me to read. I've given respondent number 2 is Senior Intelligence Officer, Bangalore Zonal Office, specific person.
Then what is the requirement of law?
Yes.
The requirement of law is you will specifically name them, make them parties, file them to file an affidavit against serious allegations against them, very serious, going by your affidavit.
Yes.
But now, what is the requirement of law? The requirement of law is they will make We made a party. And what is the basis for the learner single judge to set aside? Is their conduct
My lord,
having serious repercussions and with serious allegations?
I fully agree. My lord, may I submit something? This is not the only thing on the basis of which the honorable single judges allowed the petition. It's not only the affidavit.
Reason.
There are the process of law, there are the conclusions based on their own averment, which is all gone into.
Okay,
It
we'll
is
see
not
that.
only that.
Let's see that.
Yes.
So now, apart from coercion, based on those allegations, according to you, there is other considerations also for the learner
Balance.
single judge. Now, which
Yes.
are those? Show us that.
Madam, may we go to the order of the honorable
Yes.
single judge? It starts on page 20 onwards, my lord. Now,
One is malice in law, one is in malice on facts. The
Madam, yes.
allegations are malice, more on malice on facts.
Yes.
You know, those affidavits.
Yes.
Now, it appears that starting from 20, it's more on the provisions of the act
Madam,
and in what manner those provisions have been violated.
yes. And my lord, before I proceed, let me point out, there is some land, vacant land mention was made. That was under redevelopment. Their own statement is there. The land was under redevelopment. They came to my additional place intimated in advance. And they say, they make an allegation, it was blank land. It was under redevelopment. Lordship may see, even their own statement says it is redevelopment.
And I submitted what is there in the statement.
No, page 11. Empty land under redevelopment. It is under redevelopment. I mean,
Expected you to
these are the narratives which goes, I mean, to prejudice the case.
No, but now was that a relevant consideration for the learner single judge?
Absolutely.
It's not. No?
No,
Come
no,
to
no.
para 20.
Just my lord, he has stated.
I know that he has read. Come to page 35.
My lord, yes.
Now this narration of the learner single judge is more on the provisions of the act.
My lords, yes.
Let's read that.
Precisely.
So we are on insofar as malafide or insofar as the reasons based on certain extraneous factors. We are not, now we are going in more on the provisions of the act.
Provisions.
Let's see.
Yes, ma'am. And my lord, even lordship may turn to page 33 also. 33 for affidavit, whatever my lords have observed. Affidavit dated so-and-so relates to two statements stated to have been made on so-and-so, which can be stated to be proximate in time so as to construe retraction as being made within reasonable time of recording the statement. And
Now tell us, Mr. Kamath, who filed your affidavit, counter affidavit by the learner single judge? What is the name of the officer?
Gaurav Kumar, page 327. Respondent number 1, Gaurav Kumar. Designations.
Yes, ma'am. Let's read that paragraph.
Lordship, maybe.
Why we say is,
My lords,
ma'am, come to 182, that affidavit he has filed.
my lord, yes.
This Gaurav Kumar is not even named.
Because Gaurav Kumar may be the subsequent officer. My lords, I got.
You got it.
I got.
These are serious allegations.
My lords, yes.
Those people must be there and there is a specific. The gentleman, I can take it, we can take it. We would have gone by this affidavit also. If one of these 5 people had filed the affidavit on their behalf.
My lords, agreed fully.
You said there is a response by you, by one of these persons.
Precise.
And whatever the worth of that response, we will consider it.
My lord, I agree. I mean, let's go. So my lord, here, again, I will explain. They were there in Mumbai. Third, they called me in Bangalore. When I was sitting before them in summons, the payments were forced to be paid by my Bombay office. I was not having any access to phone or anything. So these are all the facts which, and third, I went back. 10th, I have filed the affidavit. And of course, I wanted to take action. So I have filed urgent appeal. In peak pandemic season, my lord, it was difficult for me to travel from Mumbai to Bangalore and do the thing. But let us see what is the observation by the honorable single member. My lord, on para 34, my lord, I will go to 35 also, which is very relevant. It is also significant to notice that writ petition was filed on 16/9, all within a span of approximately 45 days. It is less than 45, 3rd August to 16/9. I'm on page 34, my lords. And taking note of the explanation of inaction in the interregnum time, the time lag between completion of investigation, recording of last statement, swearing of the affidavit, filing of the writ petition, if all taken, but there is a mistake. It is 16/9, not 16/8.
You're reading 34 of the paper appeal.
Appeal paper. Well,
That's part of the order.
part of the order. Well, yes, of course. My lord's observation, I'm reading. If at all, if all taken together cannot be stated, delay in taking action has defeated the right of the petitioner to assert that the statement recorded were under duress. Even otherwise, substantive right of the petitioner to contest the recovery, which according to was under duress, cannot be defeated on mere ground of delay in taking action, while noting that substantive adjudication by way of show cause still is to be completed. Now, as my lord says, I will turn to page 35, the legal position. Regarding self-ascertainment, this is the main issue, madam, of section 74(5) attributed to the petitioner is a matter that requires consideration. In terms of the scheme of the CGST Act, it must be noticed SSE has an opportunity even before the service of notice under 74(1) on the basis of his own ascertainment of such tax or the tax of ascertained by the proper officer, make payment and inform the proper officer in writing regarding such payment as envisaged under section 74(5). Upon such payment, in terms of 74(5) of the CGST Act, proper officer in terms of section 74(6) is barred from service any notice under the subsection 74(1), though in terms of 74(7), where the proper officer is of the opinion that the amount paid under so and so falls short of amount payable, he shall proceed to issue notice under 74(1). Under 74(7) of the CGST Act states that where proper officer is of the opinion that the amount paid under subsection 5 falls short of the amount actually payable, he shall proceed to issue the notice as provided for it in subsection 1 in respect of such amount which falls short of the amount actually payable. That's what my lords pointed. In terms of 74(8), once the person chargeable with tax pays tax interest penalty, all proceedings in respect of the said notice shall be deemed to be concluded. It must be noted that payment made by the petitioner of 1 crore on 31, further 150 on 38, even if DRC3 declaration is taken note of. I'm not pausing here about DRC3, something which even I don't see it on computer. Once you file PMT6 challan, DRC3 is automatic. It is not, I don't have to do anything. It comes automatic on the computer and you have to accept that. 74, I have to write. But otherwise, it is voluntary, everything is auto-populated. And I have a note. So in note, I have written, if I can show again, Raj Chemical Payment. I have written that.
So what is the relevance of DRC declaration?
But no, DRC has no declaration. My friend says, I have intimated. That's why I'm saying it is auto-populated. So it is not, I do some active intimation.
When does this pops up, this DRC?
Once I'll file PMT6. PMT6 is also given here.
No, PMT6 is what?
Is the payment challan. But what happens?
Challan.
Let me point out. I had no mobile, nothing. So I went to office. I had to do RTGS. That's a RTGS form in PMT6. And once I give to the bank, it automatically generates DRC03. Yes. So
is it the challan is any amount, not necessarily the liability. The challan is generated, challan is paid, then this DRC03 pops up.
Pops up. Any payment today also, return payment. Okay. I don't sit on computer.
Very well,
so I have
but
to
this,
ask.
will this be relevant insofar the issue is concerned?
My lord, because the law requires not only payment, the law requires 74(5), not only the payment and intimates the officer. My lord, let me read. And my
And
friend
intimate the
says
officer.
this about the payment being made. May I read? Just my lord need not turn the pages. I will read 74(5). The person chargeable with tax may before service so and so, interest payable and a penalty equivalent of such basis his own ascertainment of such tax or the tax as ascertained by the proper officer and inform the proper officer in writing of such payment. That I have not done. That is
But
not
tell us
done.
one thing, okay, very well.
My lords,
So, you say you have not done, though you had deposited that amount,
my lords.
though your case is based on the coercion and everything.
Yes, my lord. Because the arrest, my lord, I'm the proprietor, small trader, and I was threatened, will arrest you next day if you don't pay the money. No alternative, my lord. That's, and my lord, that also I've stated. May I read further, my lord, that this
Let's
order
read
will
this.
be.
Let's read
clear.
the finding of the learned judge.
My lords. 74(8) I have read, my lord. Then I'm reading para 24 on page 36. It must be noted that payments made so and so, even if DRC is taken note of, it cannot be stated there is a self-ascertainment. For the purpose of self-ascertainment, I'm on page 37. It is clear that it amounts to voluntary determination by the assessee himself as regards the liability of tax. In the light of stand taken in the affidavit and the argument and the averments made in the writ petition on 16(9), element of voluntariness is absent and accordingly, sine qua non of self-ascertainment is not fulfilled. Though the declaration contains a declaration that the filing is voluntary, the fact is noticed above sufficient to construe that such declaration was in fact not voluntary. If it is to be noted that if the authority was of the view, this is important, that petitioner had made payment as a part of the process of self-ascertainment under 74(5), in the scheme of 74, contemplates that the proceeding would terminate either on acceptance of the self-ascertainment or if the authorities were of the view that the self-ascertainment and the amount paid under 74(5) would fall short of the amount actually payable, authority could, in terms of 74(7), proceed to issue a notice as provided for under section 74(1) in respect of such amount which falls short of the amount actually payable. In the present case, show cause notice dated so and so would clearly indicate that the notice sought to be issued would indicate a fresh, complete adjudication is not a notice as regards shortfall of the actual tax required to be paid as contemplated under 74(7), and accordingly, state itself is stopped from contending that there was a self-ascertainment. A perusal of the summary of show cause notice would indicate that state itself has not accepted the self-ascertainment. That notice is also there, I'll point out. And my lord, these observations are supported by two judgments of the division.
So there can be no
Delhi
dispute.
High Court
No,
also.
there cannot be any dispute on this.
My lords, listen.
Because the section 74(7) also contemplates if there is a short, you will issue notice under 74(1).
For the balance.
The very fact they have issued a notice, they were not satisfied, and according to them, very well. It is 2.5 crores. What Mr. Kamath was saying, the liability was much more. But in any case, the fact that they have issued notice under 74(1) means they are not satisfied with whatever is the self-ascertainment.
Maybe, my lord, they may be right. But the law says they have to exclude that amount. If they stick to that, that is the point my lords have taken here.
That observation has come.
That's the important observation.
But that amount was not included.
May I point out, my lord? It's there. I will point out. In my written statement, my lord, I've given the show cause notice also, my lord. in
Does
our
the
court.
notice, or do the notice doesn't say about his deposit of 2.5 crores?
It says, but I'll point out. My lord, how it says is important. Let me point out. My lord, I'll just, give me 1 minute, my lord. I'll find out. The page is there. We have given show cause notice. Ah.
Which page is?
Lordship, it starts from page 1 minute. Yeah. Page 19, it starts. Lordship, I turn to page 38.
Of?
Of
Written
my
statement.
reply, my written statement, my reply, my notes. I have given the show cause notice, which starts from,
Show cause notice is 15, right?
15 onwards. Yeah, 15 onwards.
Which page you said?
I'm on 38. ma'am. I'll read para 16, ma'am.
Huh.
Now therefore, Kesar Color came ground floor so and so are hereby called upon to show cause so and so as to buy an amount of 4 crore 57 availed by so and so Kesar as input tax credit on the basis of the invoice issued by Raj Chemical during the period from so and so should not be considered as irregular, ineligible and fraudulent ITC availed and utilized in contravention of 16(2)(b). The input tax credit amounting to 457 availed by them during the period 488 is reduced to 457. November 20 to July 21 without receipt of goods should not be demanded, recovered from them under 74. The amount of 2 crore 50 lakhs paid by Kesar Color Chem should not be appropriated against the demand mentioned in 2 above. They are not saying 457 minus 250, you pay so much. That was the whole observation, and my lord,
But
that is,
very good.
but-
This is only at the show cause stage.
yes.
What they say is, though you have deposited, I don't know, we have to know, possibly we'll ask them also,
Yes,
that does the provision stipulates forfeiture, even though you have paid some amount of money, like in this case, 2.5 crores, does the provisions contemplate appropriating the amount which has been done and redetermining the liability under 74(1) afresh?
so rule 142, my lord, that is 74, section 74 as we read fully, read with rule 142. May I point out, my lords?
So, but in any case, ma'am, tell us one
Balance.
thing. Now, this is at the show cause stage. Now, what has
Balance.
been put to you is, put to the SSC is, look here, you have not deposited in sum and substance, possibly it can be this only. You have self-ascertainment, you have deposited 2.5 crores, which will not satisfy the complete liability. Hence, we are issuing notice under 74(1). What do you have to say on this 2.5 crores may not be appropriated? That you will take all please, saying that, look here, this 2.5 crore needs to be adjusted. Possibly according to their reading, we will ask them also, is there any provision to appropriate? If there is no provision to appropriate, you may be right. The show cause notice must say that I will adjust this money for the balance I am issuing the show cause notice. But if there is a provision for appropriation, if they are within their rights, they can within their rights to say so, eliciting your reply and then taking a call.
My lord, precisely, that is why 74(5) speaks of self-ascertainment.
That's right.
Once they allege it is a self-ascertainment and I have paid voluntarily, then number one, they must accept in terms of 142 by issuing DRC 04, which they have not done. And then, my lord, the notice as per 75(7) and 8 must exclude that amount for the whatever falls short of they can issue. May I read 140?
Let's read that provision. The rules which you are referring
My
to.
lord, 140.
See, we want to know
My lord,
that this forfeiture is not contemplated. What
precisely.
is contemplated is the balance liability need to be determined. We want to know.
My lord, please. May I take my lord to rule 142?
And have you submitted your reply to the show cause?
Yes, this entire,
Have you said so in your reply to show cause? There is no forfeiture, only balance need to be determined?
that is what we have stated. I can point out my name.
Very good. No, let's see the
I
provision.
haven't given this because the learned judge has not gone into investigation. So I'm ready. I can, during the recess, I can take out copies and submit to my notes.
Let's see that provision.
We are on 142 rule, my lord.
Mr. Kamath, you also, whether this, what the show cause notice say about appropriating it, does it contemplate?
We are not saying that what we are demanding is 457 plus 250. No. We are saying our total demand will be 457. Out of that, since you already deposited, why should I not adjust it against your liability?
No, are you saying adjusting?
The appropriation means adjustment.
That's all.
It can be read down as adjustment.
No, that's a grievance. It appears that they are not adjusting.
75, 7 and 8.
I clearly say, my lord, look at the words, my lord. It says appropriation against the demand.
1 minute. Is it your case?
Yes.
Your grievance is this show cause saying that appropriating means they will appropriate 2.5 crores for their benefit. And they redetermine the total liability under 74(1) without adjusting 2.5 crores.
Can I submit something, madam? There is no question of appropriation at this stage.
Okay.
That is what the show cause notice.
Would you be
is.
satisfied if they say that they will adjust 2.5 crores?
My lord, they are bound to. Where is the new thing?
Yes.
My lord.
That is the short case.
Power to collect the money from me. That is the whole issue, my lord.
Our which money?
2.5 crore. They have taken, my lord, that is why allow me to show this, allow me to show some judgment. Self-ascertainment, what is self-ascertainment? Delhi High Court has discussed very succinctly and that is relied here also. My lord, even Karnataka High Court. It is covered by Karnataka High
So
Court.
what you
judgment.
are at the first stage only, they could not have collected
Precise.
2.5 crores.
Section 67 does not permit him to collect any money. And there are circulars and I will point
What
out.
do you mean
also.
by then self-ascertainment?
It is not. That's what I'm saying. They are alleging self-ascertainment. Madam, may I read one?
Oh.
A proper officer shall serve along with a notice under so-and-so 74. That's 74 is one of the section. A summary thereof electronically in DRC 01. DRC 01 is not issued to me. 142. Rule 142. And thereafter, my lord, I'll read bundle technology of a division bench judgment. Exactly the same thing.
Saying,
Our own Karnataka High Court.
saying what?
Saying that it could not have been taken. They have no right to take the course the money payment. They have no right to force me to make the payment.
No, that's a different argument.
And
we are
there is
no-
no self-ascertainment.
So in law,
My lord.
they are not taking it. What they are putting it to is self-ascertainment is the discretion with the SSC to determine what is payable by him. The benefit what is sought to be alleged is the benefit between 74(1) and 74(5) is 74(1) will entail the extreme that it will be a penalty of 100%. To obviate such a situation, we give self-ascertainment on the SSC only, realizing the mistake which he has committed. He will self-ascertain with 15% extra as penalty deposited. That's the argument.
That's the argument. That's the argument. Let me read, my lord. So this form DRC 01 is never issued to me, my lord. That is the one. This is a notice actually, notice issued. The statement under 73(2) so-and-so and 74, a summary thereof electronically in Form GSTR DRC 03, specifying therein details of the amount payable. The proper officer may, after service of notice to the person chargeable with tax interest penalty under 73(1) or 74(1), as the case may be, communicate the details of tax interest penalty as ascertained by the said officer in DRC 01A. It's a pre-consultation notice, where before the service of the notice or statement, person chargeable, these are all come after the raid, by now, after my filing the writ. It has not come before the writ. where before the service of notice or statement, the person chargeable with tax makes payment of the tax and interest in accordance with the provisions of 73(5) or 74(5), or where the person makes payment of tax, interest, penalty, or any other amount due in accordance with the Act, whether on his own ascertainment or as communicated by proper officer under sub-rule 1A, he shall inform the proper officer of such payment in DRC 03, and an acknowledgement in form DRC 04 shall be made available to the person through common portal electronically. Where is the DRC 4, man? There is no acknowledgement by them. If they allege self-ascertainment, it has to be acknowledged. Where the person referred to in 1A has made partial payment of the amount communicated to him or desires to file any submission against the proposed liability, he may make such submission in Part B, and thereafter proper officer may issue an intimation in Part C of 01, accepting the payment or the submission of both as the case may be made by the said person. Where an amount of tax, interest, penalty or any other amount payable by a person under 5274, we are reading only 74, rest of the section, we are not concerned, has been paid by the said person through an intimation in form DRC 03 under sub-rule 2, instead of crediting the said amount in the electric liability register in KMT 01 against the debit entry created for the said demand, the said person may file an
What is the
application.
effect of 74(5)? We want to understand from you.
Precisely.
What is the intent?
The intent of 74(5) is there is a self-ascertainment and I make the payment. I intimate the officer in writing, you accept this as my self-ascertainment. Officer must accept it by DRC 04. The reason is 75, 7, 8, whatever later it is said. Because once, now let me go back to 7.
Now tell us one thing. You
Hello.
say that first you have to inform.
My words.
Why was it not informed by you?
Because it was not self-ascertainment.
It was not
It
self-ascertainment.
was course payment.
What according to you would be the self-ascertainment?
But my self-ascertainment is nil because the party is live today also doing business. I am contesting 4.57 total amount. One of the party is live. He has given me confirmation. I have filed in the reply. And his 3B is also submitted, his returns.
Let's assume a situation. Okay,
Correct.
very good. You say self-ascertainment is by you, the discretion is with you. If according to you, if anything is payable under 74(5), I will pay it and I'll close it. But in this case, it didn't happen. This, according to you, it didn't happen because though you have paid 2.5 crores, you did not send an intimation to the proper officer saying that now this is what I have deposited. This is in terms of self-ascertainment which I have done. Please acknowledge it. He may acknowledge, he may not acknowledge. He may say, look here, this is short.
Then another notice, but that was he has to accept. My lord, that again, let me read.
We
74.
want to understand what is the
Please.
purpose of, the officer acknowledging.
Officer has to put a full stop to that. Then
Officer will
anything
say,
beyond that.
officer will say, we accept, acknowledge. Officer may also say, we don't acknowledge, short. 74(1) notice will follow.
No. Then, my lord, again, we have to read 74. It is not 74(1), my lord. Let me please read 74, my lord. That's not the issue. May I? Lordship, we read 74(5). Now let me read further because further sections are important. The proper officer on receipt of.
We'll come back after lunch.
My lord, please.
Lord, in court number 17, I have one parted. I'll come and join, Lord, in.
Good night, my lord.
So now only. But close not ready, open.
Okay.
Okay, let's go.
Yes, maybe half an hour.
हेलो कुठे आहेस स्नेहा? संतोष संतोष उसको जाने दो, संतोष को दो. अभी ईयरफोन मार. चलो जी घर कैसे संतोष को 2 कॉपी दिया है ना, एक वो लेटर का. हाँ वो गया. स्नेहा को दो. हम्म. हेलो मैं करता हूँ थोड़ा थोड़ा टाइम. हाँ जा रहा है जा रहा है. हम्म.
Charges rupees 39 for 30 days.
हेलो हाँ विकी दादा बोलो सर विकी हाँ વાત સાચી છે એટલે ક્યારે સંભાળી લેવાય નેક્સ્ટ ટાઈમ આઠામાં કરાવી દઈશું કંઈક યાર એટલે ખોટી મગજમારી ક્યાં હમણાં હજી તો એપ્લિકેશન થાય છે આજે એપ્લિકેશન થશે સાંજ સુધીમાં હા એ જ ને એમ એ જ ને હા એ જ કહું છું ને કે અહીંયાથી લઈ લે ને પછી કરશું આપણે કે આગળ જતા ગમે તેમ કામે કરી લેશું હા હમ. હા હા ક્યાંથી ક્યાંથી અહીંયાથી હલો જૈન પીડી છે તો એક અડધો કલાકમાં હું વાત કરી વાત અડધો કલાક કરી કરાવજો અડધો કલાક હમ હા એક ટોકન મારો ને એક ટોકન મારે રોમ કે PSP. Owners, any owners have agreement, owner agreement. તું મારી સાથે આવશે ને તું સાથે આવશે કે તું ગાડીમાં હશે કેવી રીતે આવવાનો છું હું અંધેરી વાપરીશ
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ
Take that with you. You have marked your presence on. If you save the earlier round of. The combined order.
Before I continue the explanation by Dr. I will again request to verify this. The answer the query of my words. My words were saying 75, I will say 5 is 24 1. For 6 answers that are available, the proper officer on the receipt of such information shall not serve any notice under subsection 1 in respect of the tax no paid or in penalty payable under the provisions of the Act and the rules made therein he shall not. Where the proper officer is of the revenue, amount paid under the fine or short of the amount actually paid, he shall proceed to issue notice as provided in 1 in respect of such amount which falls short of the amount actually paid. And where the person's advertisements are under the issue. Now I have a big doubt. I would request my doctor to allow me to go to the judgment of the petition of this point in case of a refractory. But she basically lied comparison. Oh, it is different. Page 162, the written judgment starts. But the description is in paragraph 15, page 166. Subsection 5, heading 6. On page 166 on the return statement. Under judgment.
No, it starts with 171.
That is the finger.
Madam, this return submissions which you are filed in the writ appeal, is it? There's a Madras High Court judgment. Madras High Court judgment.
I'm 174. 174 of
Compilation.
There are 44 questions which were raised on the file. There are 15. On page 135. In the obtaining actual benefits following issues rights, whether the amount of royalty paid during the investigation cycle, whether the amount was recovered from the public unit, whether fortunately, whether PTK officer conducted harmony and arranging the whether the restitution files whether the amount paid during investigation was currently paid under 74. Section 74 of the Act deals with elimination of debts not paid or short paid or erroneously refunded or income tax paid only recognized by reason of fraud making mistake. The relevant expression is 74(1) year very and no repeat 25 or 5 or 2 year very. Thus, 74(5) of the Act gives an option to the person to make payment of tax along with interest and 15% of payment value on its own uncertainty of the tax certificate that proper officer has informed in writing about such things. Sorry. It is pertinent to note that Division Bench of Gujarat High Court in Bhumi Associates. The conclusions of Bhumi I'll just read. No recovery in any mode, check, etc. can be made. My lord, let us keep that because he has relied on that. No issue. Next, para 19. The guidelines given by the division bench on the page 176, my lord. The guidelines issued are intended to regulate the powers of the officer carrying the seizure. The issue which arises for consideration is whether the amount of 27 crore has been paid by the company on its own ascertainment under 74(5). In the instant case, there is no record to indicate that the amount of 50 crore and 12 crore at 4M, 1M, so and so were paid on admission by the company about its liability. There is no communication in writing from the company to the proper officer about either self-ascertainment or admission of liability by company to infer that such payment was made under so and so. The company intimated the department that it reserves its right to claim refund. In my case, my lord, I have stated also in my government also that when I went on 3rd, I went with chartered accountant and I said, you at least accept my protest letter. That also was not accepted. Then, my lord, para 21. DRC 03, they have reproduced, my lord. This judgment says there was no self-ascertainment. And they are granted refund. My lord, the single member bench, in this case, that also I have attached, said that they may consider the grant of refund, but the division bench says the refund must be given. And the timeline was given. That is why, my lord, this judgment by our own division bench is important. 21, my lord, on page 177. Thus, it is evident payments have not been made admitting the liability. On the other hand, company reserves its right to seek refund and made it expressly clear payment should not be treated as admission of its liability. Besides the aforesaid, there is no material record to establish the guidelines issued by so and so were followed. So, my lord, ultimately, what is held comes later on. High-handed vagere, they have said it's okay. I will read para 30 and 31, my lords. Page 179, lordships. Then high-handed, etc. They've discussed. In my petition also the allegations were there. In the backdrop, para 30. Well-settled legal principle and the statutory provision. We may advert, page 179, to the facts of the case event. The company deposited 15 crore at 4 AM. Sum of so and so filed an application seeking refund. Thereafter, company filed an application seeking refund before judicial. Now, my lord, my issue is little different here. Let me point out. The officers from Bangalore came to Bombay. The payments were made by the Bangalore officers. After to the Bangalore, as per their directions, it was DRC-03. And after my filing the writ petition, even the show cause notices come after 1.5 years from the Bombay office. So, and one more important issue, after I have stated also, my lord, I filed my writ petition. I said, I'll cooperate. I called many times, when should I come? They have not issued any summons, nothing thereafter. Nothing has happened at Bangalore thereafter. Bombay issued me show cause notice. I'm proceeding on merit. So these are two totally different issues. The one was here, the other is going on there. May I? I'm reading 30. The company filed an application seeking refund so before judicial CST authority. Company requested to refund the amount when the attempts to seek refund did not yield any result. Writ petition was filed. Section 54 provides for a time limit of 2 years to claim refund. The company not only filed the claim within 2 years, but the writ petition as well. No rights will accrue to the department, as I'm not registered in Karnataka, therefore I cannot file application here also. That's also another technical. That's why I came by way of writ petition. Within 2 years, but the company is well within. Therefore, the light of the legal principle referred to so and so, it cannot be said there was any delay or laches. Therefore, the fourth issue of laches goes. The submission by the company that claim which is neither non-existent nor the company has rightly aware input tax credit is concerned need not be adverted to in this proceeding, as the same is pending investigation. Article 265 of the Constitution mandates that collection of the tax has to be by the authority of law. If tax is collected without any authority of law, same would amount to depriving a person of his property without any authority of law, would infringe his right under Article 300A of the Constitution of India as well. In the instant case, the only provision which permits deposit during pendency is 74(5), which is not reflected in the fact situation of the case. Therefore, it is evident amount has been collected from company in violation of 265 300A of the Constitution. Therefore, the contention that the amount be made subject to outcome of the pending investigation cannot be accepted. The department is able to refund. Now, my lord, I'll read 2 more judgment I'm submitting here, and thereafter I'll go to the single member bench judge. Because before the single member bench judgment also, Loveless was relied on. Balance. On what basis? I'm sorry, ma'am. Yes, ma'am. The amount is Madam, 1 minute. May I point out something? Because 1 minute. In para 19 and 21, they've concluded, my lord. The remittance has to be made. Page 167. Same judgment, my lords. Again, I'm on a wrong page.
No, 176. Super regiment.
167, sir. 1 minute, there is some confusion. I'm reading the same judgment. My lord, may I?
Yeah, this one.
Yeah, that's what.
176.
176, sorry. Again, I was going to the wrong judgment. At 19, I have read, my lord. The issue which arises for consideration, whether the amount has been paid on its own ascertainment. In the instant case, there is no such record to indicate that this amount, which was about so and so was paid on admission about its liability. There is no communication in writing from the company to the proper officer about ascertainment or admission of liability by company to infer that such payment was made under section 74(5) of the Act. Company intimated about so and so. In my case, affidavit is fine. Now, my lords, first I'll read to Lovelace and I'll go to the single member bench judgment also, because he has referred to the detailed issues also. Let me refer to Lovelace, my lord, first. Have to. Para 28, my lords, may I refer to? In case of Lovelace, my lord. And 19 para on the earlier page may be seen. Page 430, internal page 430. Just 2-3 lines to point out the facts were almost identical. I'm sorry, what? No, my lord. Because I was not registered here. That's what I explained, my lord. If it was in Mumbai, I would have filed the claim with the appropriate authority. Now, here was the case where the officers were here. I was in Mumbai. They came from Bangalore to Mumbai to my office. And on 3rd, I was called to Bangalore. Para 19. The only allegation, internal page 430, as stated in the counter affidavit, is the petitioner has availed ITC in respect of purchases made from certain specified suppliers during the relevant period, claiming aggregate ITC. However, registration had been cancelled from the date prior to the date of purchase. Thus, it does appear that in this case, inspection was authorized on the ground that there was wrongfully claimed. So here in this case, my lord, it was granted despite the RC being cancelled. In my case, I have a better case. Now, may I request my lord to go to para 28, where the discussion starts, the scheme of the Act. Internal page 432. May I? Given the scheme of permitting the taxpayer to voluntarily balance. Oh, you gave it just now. I'm sorry. I'm sorry, my lords. Internal page 432, para 28. My lords, given the scheme of permitting the taxpayer to voluntarily deposit tax prior to issuance of notice, either 73 or 74, to avail the benefit of absolving themselves from the liability to pay penalty either in entirety or in excess of 50% of tax payable in cases where the said tax is collected under coercion, the same is required to be returned. It is not necessary to examine in detail controversy whether such payments were made voluntarily. Clearly, where taxpayer turns around and states that payments had not been made involuntarily, and the circumstances prima facie indicate so. Taxpayer, there is some, I think, anomaly in this. So the taxpayer must be granted benefit of withdrawing such payments. Obviously, in such cases, taxpayer would forfeit immunity from levy of any penalty, and the concerned authorities are not precluded from proceeding against taxpayer in respect of any default to the full extent as permissible under the law. It is relevant to note that payment of tax on self-ascertained basis would necessarily require acceptance of the grounds on which such payment has been made. In the present case, it would necessarily be the petitioner to acknowledge the underlying liability on account of which the tax is paid. This is also required to be acknowledged by the respondents. However, in the present case, petitioner is disputed, that is all right. Now, 32 is relied on Vallabh Textile, my lord. I have the judgment copy also, I'll go to that. But let us see the conclusion. 35 and 36, my lord. Para 35 and 36. However, it appears that directions have not been implemented. In Vallabh Textile, a coordinate bench had respectfully concurred with the aforesaid directions. They are the directions which I have given, my lord, Bhumi also in the circular also. Central Board of Direct Taxes has also issued instruction, emphasizes that tax may be collected only after following due process of law. The relevant extract is given. This I have relied on also, I have attached also. Para 3, I will just read para 36. They have reproduced para 3 of the circular. It is further observed, recovery of taxes not paid or short paid can be made under the provisions of 79 only after following due legal process of issuance of notice and subsequent confirmation of demand by issuance of adjudication order. No recovery can be made unless the amount becomes payable in pursuance of an order passed by the adjudicating authority or otherwise become payable under the provisions of CGST Act and rules made thereunder. Therefore, there may not arise any situation where recovery of the tax dues has to be made by the officer from the taxpayer during the course of search, inspection, investigation on account of any issue detected during the proceeding. However, the law does not bar taxpayer from voluntarily making payment of any tax liability ascertained by him or in respect of such issue, either during the course or subsequently. Therefore, it is clarified that
121 is the instruction.
121, there is an instruction.
Instruction which is there.
Madam, my lord, on page 120 and 121 of my written submission, the circulars are reproduced. 37, it is clear from the above impermissible for the officer to pressurize to pay tax without following requisite procedure. Notwithstanding, it may be apparent that such tax is due and payable. Although it was found it is due and payable, they say it ought to have been refunded. I'm on para 37 or 34, the Lovelace. Now, Lovelace, para 37, I read, my lord. The conclusion, after the paragraph of the circulars, which are already there on my written statement 120, 121. There are two circulars given by the board. That time it was board, now it is CBI. What is? Now, Lordship, I must point out one judgment of the bundle only, which we refer to, my lord, the division bench. The single member judgment also I have attached in my written submission, which is confirmed, my lord, the facts, etc. Lordship may see page 188.
33. 33. वाची ले, mark करें वाची.
Para 33, my lord, may I read on page? My lords. Yes, sir. That's the precise principle I'm arguing. And that is what this judgment has laid down. And single bench is also reproduced, my lord. Page 188, para 33 onwards, my lord. They have also discussed 74, 74, 5 and 6. Lordship may turn to page 188 of my reply, my lords. Written submission, sorry. Para 33. They have reproduced, my lord, 74.
Just read this. Just read this. Major mark करें. Let me watch it.
I'm on para 33, my lord. 188. It requires to be noticed, provides for a procedure which is self-explanatory, relevant, etc. The procedure we have seen, my lords, perfectly everything. 5, 6, and 8, my lord. We have read again. I'm just harping on that. 5 has to be followed by 6. It cannot go to 1 straight. That is very precise, basic issue, my lord. And thereafter, my lord, 7 also they said the notice can be only for the balance. My lord, why DRC 04 is prescribed under 142 is the officer must. My lord. Yes, my lord, I'm reading. May I? Where the proper officer is of the opinion, amount under file falls short of the amount actually payable, he shall proceed to issue notice in respect of such amount which falls short of the amount actually payable. So that 250 is an acceptance by the department, which is not there. If it is self-ascertainment, then they have to issue DRC 04, which is the acceptance by the department. This we will not touch that now. Whatever may be, 15% penalty, even if they find later on, it should have been 100%, they have to accept that. That is why self-ascertainment. And my lord, the legislature was fully aware about it. Then it is there to the extent of short payment. To the extent of short payment, I have no issue, my lord. But they cannot. So, my lord, may I again read para 35 of this single member judgment, 190 page. My lords. No, it does not, my lord. It cannot cover that amount, my lord. The reason of 6. First, we have to 5. We have to go to 6, my lord. First. Correct. Yes. Yes. That paid. It is only if it is self-ascertainment accepted by them. Voluntary payment. Because, my lord, this is the whole issue. The legislature was fully aware that it is going to be some forceful payment also. So what they have written in 74.5 also, my lord, let me read again. This is very, as ascertained, last line of 74.5 on 189, by the proper officer and inform the proper officer in writing of such payment. And this interpretation is confirmed by the division bench. My lord.
Fall short means something which has been paid by the assessor.
Yes.
You may say, the other portion, not my self-ascertainment. It is something you force me to give it.
Yes, my lord.
So if it was self-ascertainment, then it may not be necessary that the revenue would acknowledge. Suppose there is a short, why will they?
Again. Then we go back there. Suppose they don't accept, my lord, let me point out. Self-ascertainment, I am saying there is no self-ascertainment. It is coercion, correct? Now they say they have made on your own. And we have acknowledged under DRC 03 and everything. Once you say that this is self-ascertainment, they have to accept it first, my lord. And they shall, that's a word.
Self-ascertainment, and the principle you must accept, look here, I have carried out a self-ascertainment. You may not be agreeing with the amount.
No.
But there is a distinction. Distinction means you are acknowledging self-ascertainment, but you are not acknowledging there is a short payment. Or you are not saying there is a complete payment. There is a short payment.
Yeah.
Self-ascertainment, short payment, hence notice. Self-ascertainment, acknowledging self-ascertainment, but shortage of payment, hence notice. That's all you must have.
Correct. But that is why, my lord, 74.5 says they shall serve the, I mean, may I read 35 is the conclusion, my lord, 190, same judgment, single member judge, that is the conclusion which is accepted by the division bench. Page 190 of my written reply submission. Accordingly, it is clear, procedure for self-ascertainment in the 74(5) contains a scheme that is concluded after following the procedure under 6, 7, 8 of the 74. In the present case, it must be noted, though there is payment of tax, even if it is accepted, payment is followed by DRC 03. Mere payment of tax cannot be construed to be payment towards self-ascertainment as contemplated under 74(5). That is what the division bench accepts, that once if you say that this is self-ascertainment, but if the dealer turns around and says that no, this is not a self-ascertainment, this is a coercion, then you have to, and that is why, my lord. Now let us read the single member bench judgment. No, no, our own judgment.
What we are saying is also what we are.
My lord, yes.
Principally self-ascertainment.
Yes.
By the SSC. Please
Correct.
acknowledge.
Yes.
That acknowledge must not be construed, whatever the SSC has paid has been accepted. This is principally accepting self-ascertainment, you have done self-ascertainment. We acknowledge, but according to us, this is what is more payable.
You may issue notice for the short.
That what follows self-ascertainment. According to the SSC, which is not so accepted by the SSC, but not on the end. Will it follow? Then where is the necessity for them to refund you back?
Because it is illegal collection.
If it is self-ascertainment, then no.
Self-ascertainment, then no. Yes, my lord. My lord, yes. My lord,
Just like this, I'm an SSC.
my lord.
The action taken, I say, according to me, nothing is paid. And I have, let's assume for a moment, there is some self-ascertainment by me. Based on that, I say, okay, though nothing is payable, I will still give you 100 rupees as a GST. If it is 300 rupees, they may say, look here, this 100 rupees would not suffice the complete liability. It should be 200 rupees. But that 100 rupees which has gone there, where is the requirement that 100 rupees need to be refunded to you? Because this is something, 100 rupees is only a part payment, not the complete payment.
Correct. If it is part payment, if it is self-ascertainment accepted by them, then what my lord says is right. They need not be refunded because that chapter is closed. My lord, once self-ascertainment is accepted, yes, it is an illegal recovery. Yes. And my lord, let us now.
In case of self-ascertainment shortage, you may not be even arguing that amount need to be refunded.
Of course, my lord. Yes, precisely.
Self-ascertainment I have paid on my valuation. But in case of self-ascertainment, anything paid that cannot be recovered. But if it is not a self-ascertainment, it presupposes two more conditions.
Please.
Then in that eventuality it must come back. That's your case.
Precisely. That's a small case. Yes, my lords have understood very correctly. Now with that background, my lord, may I read our own single member bench judgment, which is, okay. Yes, bundle technologies.
Just come to just see that paragraph.
My lord, yes.
But that single bench judgment which you want to refer to is went to the division bench.
Yes, of course.
Remain undisturbed. Huh? Division bench is not disturb the findings.
My lord, division bench judgments starts on, yes.
176.
1 minute, 176.
This one. 171.
171, sorry, my lords, my mistake. 171, there are multiple judgments. My lord, one thing very important. The single member bench findings are not disturbed. And they have ultimately said, if I may just refer to the last line, for the aforesaid reasons, we concur with the conclusion recorded by single judge to the aforesaid extent and finding. I will refer to. My lord, now let's go to division bench judgment at ease, as my lords are very rightly referring to it. May I start with para 4, my lord, 173. Just the facts, almost identical facts. For providing service, Greenwich raised valid tax invoice on the company. I'm on page 173, para 4, which was paid on so-and-so, so-and-so. And the allegation is on the next paragraph. Investigation was initiated. My lord, I came straight to the court. I came within 1 month to the court. The Bombay office will not entertain my application. Here I was not registered also.
My lord.
I need to pay some tax. I will say, subject.
Yes.
The money satisfies the tax. No, it cannot. Otherwise, how will they fulfill the shortfall? No, but I'm not satisfied what the amount we have given. It's a short. Your liability is this, and this is the notice which I am showing. Please reply. Okay. What is contended is, if it is a self-ascertainment which you acknowledge, then it is the only shortfall for which you will take action. Okay, there is no question of refund. But if it is not self-ascertainment, something which you have cost on me, I give that money. My case is no tax is liable. You have issued 74(1), you will carry out the investigation, I will reply. But pending that, you will refund this money back to me.
That's what the stand of the my lord now the index.
That's what she is relying upon.
Yes. My lord, the lordship may kindly turn to page number 190 of that judgment. The stand of the my lord, the department as well as the assessing. There, your lordship may kindly come to my lord, page 30, para 34, my lord. I have extracted the provisions of the act and discussed about it. My lord, 35, and may I read from 35, my lords? Paragraph 35. Accordingly, it is clear that the procedure of self-ascertainment under subsection 5 of section 74 contains a scheme that is concluded after following the procedure under subsection 6, 7, and 8 of the section 74 of the Act. In the present case, it must be noted that though there is a payment of a tax, and even if it is accepted that payment of a tax is followed by a requisite challan DRC 03, the mere payment of a tax cannot be construed to be a payment towards self-ascertainment as contemplated in section 5 of the CGST Act. The letter of the petitioner dated so-and-so is clear and ambiguous, wherein it is asserted by the petitioner that the amount is made in furtherance of their goodwill conduct and bona fide, and that it is made during the pendency of the inspection proceedings, and the deposit is without prejudice and with reservation of rights, and contention to seek necessary refund at the appropriate time, and should not be regarded as an admission of liability. Or this is the first instance, my lord, in that case, they say that, my lord, this is in the goodwill conduct and bona fide, and this should not be accepted as a, my lord, admission of a liability. That is the first stand taken by them, my lord, before the authorities. Now, my lord, 37. So there is a distinction. This is a distinction on factual aspects. My lord, here there is no such a thing, my lord. In this, my lord, they did not address any letter to us, nor that affidavit was filed before any of the authorities, retracting the my lord, admission of a liability. My lord, that affidavit deposit. They said they alleged that, my lord, coercion was, my lord, under coercion and duress, my lord, they were forced to make the payment. No such admission was, no such, my lord, this thing was placed before the authorities. To say that this is only in the goodwill or under the threat or a coercion we made under protest, this should not be considered as a voluntary payment. They never made such a statement before any of the authorities. My lord, the retraction has to be immediate. If my lord, if they say that, my lord, the chronology of the events they give, 3 days, my lord, they were there. After 4th day, I came to Bangalore. From here, I made a payment, etc., etc. Retraction, my lord, if they wanted to retract, it should be immediate, not an afterthought. That's the difference, my lord, whether the payment is voluntary or not here. If, my lord, lordships have rightly put it. Now, my lord, if the 100 rupees is the liability, according to me as an officer, he says, no, 100 rupees is not the liability, only 20 rupees is there. Now, my lord, I will accept his liability to the extent of 20 rupees. I will confine the further proceedings only to the 80 rupees, according to his submission. Now, my lord, he says, for the first time, no, I will not admit any liability. I approached the High Court. You proceed in accordance with law by issuing a show cause notice. Now, the finding of the learned single judge is, I should have confined the show cause notice, excluding the 2 crore 50 lakhs. That is, my lord, one of the findings is, since I have not excluded that cannot be construed as a voluntary. That is, my lord, the finding of the learned single judge, apart from this allegation of coercion, etc. Now, my lord, the lordships may kindly see, my lord, the 142 my learned friend has read out. My lord, I can proceed. My lord, DRC 04 is the, my lord, the acknowledgement. That was not there on record, my lord. That is not there. It is not given. My lord, that is why, my lord, we proceeded to, my lord, to issue a show cause notice, because he says at the later stage, I will not accept a single rupee liability. Acknowledgement can be given only when he says that, my lord, I accept only to this extent. I could have given an acknowledgement to that extent. That's one aspect, my lord. Now, my lord, later stage, he says that, my lord, I approached the High Court. You do whatever you want. I am not accepting the liability. After my lord approaching this honorable, he says, not at the earlier point. Now, my lord, there is a provision under the rules. My lord, he may raise objections to the ascertainment made by the officer and say that he is not accepting the liability. At least, my lord, if he had accepted the liability to the extent of 2.5 crores, I could have, my lord, issued an acknowledgement. But first he makes it as under voluntary category. After the, my lord, filing of the writ petition, he retracts it. He did not agree. Quantification. That is only a quantification. My lord, even under the, my lord, the show cause notice, the adjudicating authority says it is paid 2.5 crore rupees, whatever is paid, my lord, is liable to be appropriated against the demand. See, my lord, those wordings may not be, my lord, of the what is used in the statute. And I think, my lord, my learned friend is appearing before them, I believe.
Lordship, what has happened in this case
Depending
is
on
that
the pendency of the cases.
1st December 2022 was when the show cause notice was granted. There were several documents and everything that were needed. The reply was submitted somewhere around July 2023. Personal hearings have been done, but till now, Lordship, no order has been granted. No order has been passed. Yes, Lordship, whatever was required, my written submission, everything is there. Lordship, don't.
We'll instruct them, my lord. We'll instruct them to pass an order, my lord, with an.
Say you are entitled to that money back.
Yes.
case. But when did they last ended the proceeding?
My last letter is November 24, right? I have been giving them whatever detail they ask for. My lord, the real reason is, let me just, it is on merit. Raj Chemical exists today, doing business today. He has given me confirmation also, I have given my lord in my reply. He has given confirmation that I have transacted with you. And my lord, let me point out something. Suppose they find out in the show cause notice or show cause notice goes against me, I would pay 10% and go in appeal because I know my claim is right. Why I would pay 10% and go in appeal? Why would I pay 2.5 half crore?
If an appeal has
Because
to
that was
prefer,
not the whole issue is, my lord.
If you had not paid it,
I would have paid 10% and gone.
they have determined the final.
Yes.
Your entitlement to pay is pre-deposit only 10%.
Of
Yes.
course, yes.
Of the 4 crores which they say they have.
Yes, my lord, that's the law.
107 of the
107, yes, my lord. No, my lord. The legislature,
my lord, Your Lordship, I can appreciate one thing, my lord.
And have you acknowledged?
My lord, when they say that, my lord, it is a voluntary under DRC 03. From there, my lord, it is a self-ascertainment. My lord, that's one procedure lapse on our part, my lord. I don't, my lord, dispute that. Some technical glitch, my lord, they said while generating that acknowledgement, something, my lord. Though, my lord, even otherwise also, my lord, that's only a, my lord, I would say, my lord, it doesn't, my lord, is not a substantial this thing. It is only a procedural. Yes.
I am not liable to pay.
Single rupee. Yes.
Self-ascertainment with a nil liability.
Yes.
If nil liability to issue this, even if you determine 4 crores or 5 crores, I will pay 10% of it and proceed.
File up.
So if that is so, then my lord, this 2.5 crores must come back, and 10% will be, suppose let's assume hypothetically, you say 4.5 crores, according to the view, 4.5 crores liability of 10%.
45 lakhs.
You are out of pocket with the 2.5 crores.
My lord, one submission, my lord, I would like to make, my lord, in this context, my lord. Where this money goes, recovery, what they is contending, ultimately, my lord, where it goes, till the adjudication proceedings are concluded. Whether will it lie with us or we are entitled to utilize that amount, my lord. No, no one does, my lord. Now, even some minuscule percentage of this kind of self-assessment, they also retract it subsequently.
my lords, in show cause
No one does.
notice, my lords,
Yes.
if I'm right, if I'm believing I'm right, let me put it that way. But my lord, let me point out, I've got hundreds of show cause notice wherein part we are accepting also. We are saying, yes, this point not debatable, we are making payment also. It is not that always we agitate, my lord, no. Because the dealer is fully aware of his liability of interest and penalty. My lord. General, yes. Dishonesty, there is no limit, my lord. I am not for dishonesty. My lord, dishonesty, I have no answer. I will not go to that answer also because I fully agree what my lords are presuming. But the fact is, I have business with Raj Chemical since last 2 decades. And I am not the fly-by-night. I continue to carry on business today also.
Please.
What you have said, they do acknowledge presupposes. Then can you retain that photograph? Okay, the second question. First answer this, then we'll come to our second question. What is?
My lord, it is only a procedural aspect, my lord, I would contend, my lord. The voluntary nature of the payment will not get diminished by, my lord, me not, my lord, acknowledging or by issuing a DRC 04. On record, we are saying that, my lord, it is a voluntary payment. That's, my lord, my lord, it is, no, it is, my lord, it is a transparency, my lord, in the system, to maintain a transparency in the system. My lord, such a thing is provided, my lord, by way of an abundant caution, my lord. I am acknowledging it, my lord. If I.
But you are not satisfied. I don't require, I don't want to give an acknowledgement, look here, but still you are, this amount is short by this much.
My lord, the list is only to that extent of that amount, my lord, remains after that.
Passing order, when was the last proceeding, sir? See, you can say that the matter was pending before this court. If we did not pass an order.
No, my lord, that has nothing to do with the, my lord, the pendants of the matter, my lord. No, my lord. My lord, writ petition is only.
No, this investigation is after show cause.
No. My lord, this adjudication is after show cause. Investigation is concluded long back, my lord. No order is yet to be passed. That's what they are complaining, no, my lord. There is a delay in passing the order by adjudicating authority.
That will determine this fate of this 2.5 crores also.
My lord, that will, now it incidentally, my lord, deal with this also. Because the entire liability is 4 crores 75 lakhs. If the authority comes to the conclusion that, my lord, the liability is 4.75 crores, my lord, then this will be appropriated against that demand. If, my lord, there is a nil liability, my lord, it will be refunded to.
My friend. Your point is 2.5 crores should not be with them. Should be with you.
No, it should not with us, my lord. My lord, I may point out, my lord, one thing. My lord, I'll just scheme of that. My lord, this collection, my lord, where it goes, if I collect, my lord, 2.5 crores, my lord, where it lies, whether it lies with the Government of India account or with, my lord, whether I'm entitled to utilize it for any purpose, so as to, my lord, this. Now, my lord, it be, if any tax or interest or a penalty which is deposited by the, my lord, the SSC, it sits, my lord, goes into a, my lord, a cash credit ledger, electronic cash credit ledger. It will be in the ledger. After the, my lord, determination by the authority, it gets, my lord, reduced to that. But SSC only maintains it, but he cannot utilize that.
What happens is, I just give you a regular separate. Tomorrow I have to file results. So what do I do now? I take certain ITC. I have particular savings. I adjust the ITC. And there is something that is being paid to cash. So what I do now, I don't directly go and pay the rent because there is no money.
Yes.
I deposit it in my cash credit. And then write the returns I have to. When I file the returns, I state that this is the amount which is there in my cash. Now, not sure what happens. Suppose there is an audit or something which happens quite regularly. They realize that there are certain wrong ITC that I have claimed and everything. I don't want to then contest. Now, the returns I cannot file the return. At that point of time, what do I do? Is I first deposit the money in the cash credit. Or if I have electronic credit, then when I file DRC 03, it is out of my account. It is out of my head. So it is not with me.
This is the account. Electronic account.
Suppose there is there in the refund rules. Suppose I deposit, there is CGST, IGST. Now suppose I wrongly deposit tax in CGST, which I after deposit in IGST. There is a very easy challan which is given to just transfer from one place to the other. But that amount
cash return, that is for me to use. Suppose I have paid extra, I can claim the refund of it very easily. Once I have DRC 03 law, that was it out of map. And DRC 03 law, there was no two things. DRC 03 can be filed on the basis of, because also have a electronic credit ledger and cash ledger. Both are tax ledger. I can pay through electronic credit also, I can pay cash. So this is out of your pocket. It is out of my pocket. Lordship, it is not.
He can't utilize it. He can't utilize it. He can't utilize it. No, no, no.
It is like making, that is simplified. But then suppose earlier there used to be a wallet transfer. What did I do? I deposited 1,000 rupees in the Paytm wallet. Now if I go and buy tea and I have to pay 20 rupees for the tea, I go scan the QR code, 20 rupees now. So look at that wallet as an electronic cash return and 20 rupees as a payment, which is now asserted. So it's as good as one utilizing.
Right, it's, my lord, provision says that, my lord, every deposit made towards a tax should be in cash ledger. He can't utilize.
What will happen?
My lord, 2.5 crores, my lord, if liability is nil after adjudication, it will automatically gets transferred into his account, my lord, credited into his account. And if it is, my lord, on that amount, my lord, section 50.
If they pass the order, suppose it is nil also. 2.5 crore will go to credit ledger and never get it back. They will give refund also.
Refund will come. Refund will come. That, but I am saying it will go to their account now, ma'am. No, it goes to him, my lord. It goes to him.
Scenario that my senior explained. One is presuming that the local notice is adverse. In that case, what if there is what
Appeal.
want to have, if I appeal, I have to pay
10%.
I have to pay what? Now, yes, but if at all, they are now saying that your liability is 4.5 crores, but we want to now appropriate 2.5 crores. So if it is not there, what is now, what will happen? What? 250 and 11 will 10%. Now they say, okay, I want to appropriate. Can they tell them?
Let's assume liability is fixed from 4.5. 10% comes to much below 2.5.
Yes.
That 10% will be retained, balance can be given if you find an.
No.
But what will happen now? Because they are proposing to see the question before the local notice authority is not whether it is 10% again or not 10%. So that now what happens? Just sorry, 4.5 crores, 2.5 crores. Now what happens? That is the same scenario. If everything goes against me, 4.5 crores is made payable because 2.5 crores is now appropriated. The liability now stands at 2 crores. I have to pay additional 20 lakhs.
You're right, for 10%.
Yes, I have to pay additional.
No, that's what we are saying. 2.5 crores is there. Let's hypothetically, let's say 4.5 crores liability has been fixed, no bill. 4.5 times 45 lakhs. They will retain 45 lakhs and rest paid to you. That 45 lakhs would be considered to be as a fee deposit for the purpose of fee.
That
we will ask them. Yes, we are only saying this, but
Yes.
what you're saying will be going by the division bench, possibly. I recollect in one of the matters which even considering this possibly a video was done.
The proposition by yourself, that would mean they will compulsory, despite not having good case, giving the details, they will say, no, we are passing.
Let's do that. This is only, we say nothing on of the final order to be passed. What is the final order? This is the final order. When we pass a final order, we will see, we will decide to retain the appeal. Pass a final order. But generally, is there any limitation by to pass a final order?
There is a, my lord, the limitation is that. 7410. Please. Acknowledgement. Acknowledgement.
It is not what follows.
My lord, in the show cause notice, my lord, we have, my lord, acknowledged that, my lord, it is a voluntary payment. In the show cause notice. In the show cause notice issued, my lord, that authority says that, my lord, it was voluntarily paid. We, my lord, seek to adjust it against the final liability. Only thing is that, my lord, that form 04, DRC 04 was not generated. That's.
Two eventualities. 04 not generated would still be a voluntary pay. 04 generated will be a voluntary pay. Each of these eventualities will be voluntary.
My lord, I would, my lord, submit this, my lord. 03, which generated by the, my lord, the system on payment of, my lord, payment is the, my lord, the voluntary payment on part of the assessee, my lord. That my acknowledgement becomes only a consequential. Yes, 03 is generated by them. See,
Some money has come.
no, my lord. That, see, my lord, that 03 column says it's voluntary. Lordships may kindly peruse that, my lord, 03 for a moment. See, Lordship may kindly.
What happens? Now, if I just have to take the example of it, say, hypothetically, DRC 04 was everything procedural defect and now it is open notice their economy. But how can that be? DRC 03 is filed in 2021. Your so-called notice is December 20.
Whatever it is.
Till that it is not acknowledged. Till that it is not acknowledged. And not if you are acknowledged, most important, if you are acknowledging, presuming that DRC 04 is a procedural defect because most of the time it is us who come stating that machinery provision should not override the substantive. It is us who come. Presuming DRC 04 is
Procedure.
out of some error. The show cause notice ought to have first given me notice only for 2 crore rupees because according to you, 2.5 crore is same as a thing.
That is what.
Both the actions are both the actions. If it is voluntary according to them, super notice is not ignoring now. Super notice ignoring. Super notice as per 74.5 is for the balance payment only. Next year as per 74. That's what.
There is always income tax sales tax portion paid in present. Therefore, they say, and informs in writing to the proper officer. 74.5 does not say by making the payment as the only. 74.5 is very clear on that aspect. Where is that implication value? 03 is automatic channel, which always comes, but intimation in writing. See the word is made. Ascertain and inform the proper officer in writing of such payment.
My lord, may I make, my lord, request? Page number 36 of the compilation which they have filed.
Yes.
04, my lord, 04. That is their grievance. Yes.
Yes, now my notice, suppose show notice, investigation. I think it is a notice, whatever, say, 100 rupees, there is rate of tax insurance 500 rupees. I will say, no, rate of tax I will not agree, or maybe I will rate of tax and not whatever reasons I have, but whatever I agree, I have to do this stuff. That this is acceptance, more than acceptance of this point.
It is a regular thing that happens, especially at the scale of very regularly people accept that, but nobody wants to contest and litigate for
smaller amounts.
smaller amount.
5-7 lakhs, Small items going to appeal is more costly.
I just,
Rate of tax, suppose Supreme Court decides something, or the Jurisdictional Court decides something, I have to accept. No, I accept it. You pay.
may I request, my lord, for a moment, my lord, page number 36 of the compilation. Ascertain it, my lord, I will immediately ask, because it is Bombay GST authorities. Yeah. We'll ascertain it, my lord, not.
They will not be allowed.
Well, just page 36 of their compilation, my lord. Part of the show cause notice, I just want to read, my lord, for better clarity. Paragraph 13.1. Mr. So and so have affected the following payment voluntarily towards the irregular availment of ITC through DRC 03. Details of the same is as follows. The DRC. So that's fine.
You are asking.
Yes.
It has to be voluntary.
Lord,
Or presumption is voluntary.
voluntary.
The point, the matter, the foundational facts.
Yes.
Based on that affidavit, they say these are not voluntary. That's something you have to post.
Oh, that affidavit was not before any of the authorities, my lord. That's our thing. It was first time before this honorable court. See, in those cases, my lord, they contended before the authorities that it is involuntary. DRC 04, 5, 6, and 7. My lord, their case is that if it is according to the understanding of the department, if it was a voluntary, then they should have excluded this amount from the show cause notice. The mere fact of, my lord, they including this amount in the show cause notice itself indicates that it is not accepted as a voluntary payment. That's the sum and substance of that case is, my lord, that's it. No, I'm not admitting, I am saying that it is your case. Adjudicating authority says, my lord, it's a voluntary.
Then the need to be recruited.
Division bench says so, my lord, in bundle technology. But the facts were a little different, my lord. That's what I'm trying to say. There was communication, and my lord, they say that, my lord, it was paid during the course of the investigation. My lord, 111. That is in the month of, one is a month of July and 21.
10th August 2021, extraction affidavit, and lordship with great difficulty during COVID, 16th September, writ petition. 21.
From where to Bangalore, we have filed.
21, my lord.
Second phase.
Second phase. 31,738. These are two payments. 111, 113.
Now, lordship, in an ideal scenario, a lot of things could have been done. But a business person, lordship, just understand, as per instruction also, and they are not at the university. 29 they come, according to the left at 12:30, they are having 11:30. They come 2 days, they are in my office.
190 square feet, my lord.
They are sleeping there, lordship. They are in my office. And lordship, the point is, The search proceeding has ended, the investigation is not ended, because when I'm going on the 31st, he gives me a super summons stating come on the 2nd. I say, have some mercy, let me come on the 3rd. And on the 3rd, Lordship, what happens is not part of the record, but what happens is, I have 3 MSN group recoveries, my mobile phone is not with them, the officer, so that it could have been a background party, so the officer calls and checks that you deposit the money. When I go, he says that after account, your account 1.5 crore has come, now we make the payment. Now, again, Lordship, if 1 crore was paid at that point of time, because it was paid on the next day, because I was in person. But 1.5 crore, Lordship, while I was here, I called it, why did I look at someone? Why did I look at
Yes, anything else to say, Mr. Millerman? Come on, we are having tomorrow, day after tomorrow. We have anything to the area of computer and we will go.
Well, one day, my lord, let the ASG, my lord, speak, because on my part, my lord, I think, my lord, this should. Yes.
Then we'll have, no, just say we will try on this Monday.
16, 12.
16. Please.
Yeah, Mr. Ramakrishna.
Ah.
We have heard
16
that
March.
that we will just brief you on what really transcribing offer is and what are the submission on behalf of. So we are ready, we can take it up now.
Monday next, Monday.
Or on Monday next.
Monday next, my lord, 16th, all right, yes. Yes, yes. Yes, my lord. Just a short, quick rejoinder. I'm grateful. He's a
Everything.
Serial number 33.
For the respondents in this matter.
My lord, the counsel, my lords, Mr. Amarnath, my lords, is held up in another court, my lords. I believe, my lords, when Ms. Lakshmi Menon is also not available right now.
I'm appearing online.
I was told, my lords, that that if he can be accommodated next tomorrow or day after, my lords, he's in another court. Very well, my lords.
Serial number 40. 40.
I'll call him, I'll call him.
27th January. Serial number 46. 46.
My lords. I'll just get my judgments minutes. I'll just get my judgments minutes. No, I will come projects. I'm unable to find the court copies of my judgment, my lords. I have my copies, but court copies of judgments, my lords, I'm unable to find it. I've segregated it right now. Yes, my lords. Anyway, I'll start, my lords, I'll come to that. Just hold it for me. I'd bunch it up everything. My lords, this is a matter, my lords, where an assessment order was, my lords, sought to be revised by the Principal Commissioner of Income Tax. Now that order of revision, my lords, had set aside the assessment order on one aspect on commission of sales. Now that was, my lords, challenged before the assessee challenged that before the tribunal. My lords, the tribunal has set aside the revisionary order and restored what the original AO order is, my lords, and hence we are in appeal in the order, my lords. We are for the assessment year 15-16 because, my lords, a lot of proceeds will also happen because why rely upon, my lords, the earlier years, the assessee will rely upon subsequent years, my lords. So this is the nature of the order, my lords. May I please request the court, my lords, to come to the revisionary order, page 113. What was the order sought to be revised by the Principal Commissioner, my lords? Page 113, my lords. Sir, 113. Sir, sir. Thank you. May I please request, my lords, para 2, my lords? Yes. It has been observed that the amount of 36 crore 34 lakhs 10,000 towards commission on sales debited by the assessee to profit and loss accounts without TDS was not disallowed under section 40 AIA in the assessment order. Failure to do so has resulted in the short computation of income of rupees 10 crores, 30% of 10 crores of that, 30% of 36 crores, which a consequent tax effort of 5 crores 74 lakhs 38,221. In view of the facts, the assessment order was considered to be erroneous and prejudicial to the interest of the revenue in terms of 263. It is therefore proposed to pass an order under 263 in this case. A show cause notice was issued on 19/3/2022, giving an assessee an opportunity of filing submission. In response, assessee has filed a reply dated 22/3/2022. The submission filed by the assessee has been carefully considered. The assessee claimed that this issue was considered by the AO during the assessment proceedings is not acceptable considering the facts discussed above, particularly as assessee has not filed necessary evidence along with his above reply to substantiate these claims. Considering the fact, it is clear the TDS was required to be done on rupees 36 crore debited by the assessee to the profit and loss account towards commission on sales. As the assessee did not do TDS on this amount, the AO should have disallowed this amount of rupees 40 under section 40 AIA. The AO has not made this disallowance, even though similar disallowance has been made in assessment year 13-14, 14-15. The AO has erroneously not made the disallowance in the assessment order, not making this disallowance is contrary to the law. Now, para 5, this is not a case where assessing officer has taken one of the legally plausible views. Not making the above disallowance is legal and tenable. Moreover, the Honorable Supreme Court in Constitution Bench has recently held as follows. Well, I'll skip that, my lords. In view of the above, the interpretation based on some expert that if two views are possible, one favorable to the assessee, one has to be preferred is no longer good law. The argument of the assessing officer has taken a plausible view and therefore assessing also cannot be not acceptable. Next paragraph. Moreover, this is not a case where assessing officer has taken one of the legally plausible views. In this case, assessing officer erroneously not made a disallowance, and this clearly is contrary to the law. So here, my lords, he had to deduct it, he had to disallow it, but he's not done it. That was subject to, my lords, a revision to your order saying that this is an erroneous, also prejudicial to the interest of the revenue. Hence, we sought to revise the order. Now, my lords, para 8, my lords, is important. That is the reasoning based after the reliance of a judgment, my lords. Para 8. I discussed above the TDS was required to be done on rupees 36 so and so, debited by the assessee to the profit and loss account towards commission on sales. As the assessee did not do TDS on this amount, the AO should have disallowed this amount under section 40A. The AO has not made the disallowance, even though similar disallowance has been made in assessment year 13-14, 14-15. AO has erroneously not made the disallowance in the assessment order. Not making the disallowance is untenable in the law, and failure to do so has resulted in a short computation of income with a consequent tax rate of so and so. This has resulted in loss of revenue. Considering this facts, assessment order erroneous and prejudicial to the interest of revenue in terms of section 263. Para 10, my lords. In view of the above discussion, the assessment order under 143.3 is erroneous and prejudicial to the interest of the revenue in terms of 263. The assessment order is accordingly set aside for this purpose, and the AO is directed to under section 263 to make a fresh assessment in accordance with the law after considering the above. The AO shall examine the issues discussed above and conduct necessary inquiries into the accordance with the law and CBDT guidelines. The AO shall consider the disallowance under 40A of the transaction discussed above. It shall give assessee an opportunity to furnish necessary evidence to establish his claim and explain why the proposed additions to be made to be not income. AO shall consider facts. So, my lords, matter is relegated back to the assessing officer. Now, what is more important, my lords? The AO, my lords, when he passed the original order, does not make any mention to this. He has simply disallowed it. The order is silent as to why he did not pass an order. So that is something, my lords, today from the AO order, my lords, of assessment order, one cannot decipher as to whether he might have looked into the merits, but he said nothing about it. He's silent. Now, my lords, no, that is this order was subject matter challenge before the tribunal. Yes, my lord. This was subject matter challenge by them. Yes, my lord. The tribunal allowed that order. Hence, we are in appeal now, my lords. The only reason, my lords, why matter of concern is that the AO, my lords, when he sought for explanation from these people, from the assessees, must have made some sort of a finding, my lords, today. Otherwise, we do not know on what reasons he has disallowed today. Based on, my lords? No, not yet, my lords. Not. Yes, my lords. Yes, my lords. That's an annexure A, my lords. Is 5 odd crores, my lord. That is the loss to the revenue, 5 crores. Yes, my lord. He had to do, that's at page, para 113, my lords, para 2, my lords. That's at page. A failure as resulted in short computation of income of rupees 10 crores 90 lakhs at 30% of rupees 36 crores 34 with a consequent tax effect of 5 crores 74 lakhs. That is a tax effect, my lords. 5 crores 74 lakhs 38,221. Yes, my lords. So please look at, my lords, the tribunal's order. Well, may I please read, my lords, para 5, my lords, because here there's some submissions made by the DR which will also be relevant for me. The DR, on the other hand, has placed report of the AO dated so-and-so, page 5 at page 16, my lords, para 5. The learned DR contended that the AO for assessment year 13-14 and 14-15 and disallowed the commission payment since there was no deduction of tax at source. And the AO for the relevant assessment year ought to have followed the disallowance that was made in the assessment year 13-14 and 14-15. It is further contended by the learned DR there is nothing in the assessment order to suggest that the AO had conducted sufficient inquiry for allowing deductions of these commission payments amounting to so-and-so. It is further submitted, but this is more important. It is further submitted by the learned DR that for assessment of 13-14 and 14-15, the tribunal had restored the matter in the appeal filed by the assessee to the AO to determine whether the payments made by the assessee to the distributors is a discount or commission. Therefore, it was contended that similar view may be taken for this assessment year also. So, my previous years, tribunal said, please let the AO look into it afresh. But in this case, the tribunal has set aside the order of the revision. Now, my lords, para 6. We have heard the rival submission and produced the material on record for the relevant assessment. The assessment was selected for scrutiny. During the course of the assessment proceedings, AO had questioned the impugned transaction of the expenditure amounting to 36.34 crores. The relevant portion of the notice dated 22/11/2018 directing the assessee to explain the commission expenditure as follows. So, my lords, the AO, my lords, looked into it as at the time of assessment, also issued a notice to them. The notice, my lords, dated is 22/11/2018. A response was also filed by the assessee. Not being satisfied, my lords, another show cause notice comes to be issued by the AO. That's, my lords, at para 8, my lords, page 21. The tribunal, my lords, has culled out the entire reply at page 18, 19, and 20, my lords. At para 8, my lords, the assessing officer issues another notice dated 12/12/2018, which again reply comes to be filed. So that has been culled out at page 22, 23, 24, my lords. 25 is the reasoning of the tribunal, my lords. Page 25, para 10. From the above show cause notice issued by the AO and the reply submitted to the assessee, it is clear that AO has examined the impugned transaction in detail. The question is where, my lords? He's not. A bare perusal of assessment order, my lords, is silent on this. The perusal of the assessment order, my lords, is silent on this issue. That's point number 1, my lords. AO has examined the impugned transaction in detail during the course of the assessment proceedings for the year under consideration. The assessee during the assessment proceeding had admittedly placed on record distribution agreement, no doubt, my lords, and the debit notes. From this, the only inference that can be drawn is that AO has taken a conscious decision in not making the dissolution under 40A of the Act. My lords, we do not know, my lords, where the tribunal is getting this finding from, because AO has not said nothing. Therefore, the PCIT reasoning that the AO has not examined the issue in accordance with the law has to be and has conducted necessary inquiry is incorrect. Since AO has taken plausible view, the question is, was a view taken in the first place? The said assessment order cannot be subjected to revision under 263 of the Act. In this context, we rely upon the Honorable Apex Court in the case of Max India Supra Limited. Further, the latest judgment of the Honorable Jurisdictional High Court of Karnataka in the case of Crensos or so-and-so clearly held that question whether there has been application of mind before allowing the expenditure has to be examined from the record of the case. It is further held that the Jurisdictional High Court, when the assessee has filed all the details before AO and AO has accepted the contention of the assessee, it is deemed that the AO has taken a plausible view allowing the claim of the assessee. The relevant finding of the High Court is called out, my lords, para 12. Moreover, the report of the AO submitted to the learned DR, it is clear that the subsequent assessment 16, 17, 17, 18, 18, 19, the commission expenditure was not disallowed in the final assessment order completed in those assessment order. It is pertinent to mention the above said assessment order. AO had called in question the allowability of the commission during the course of assessment proceedings, and assessee had filed similar reply. It was filed for the impugned assessment year. However, no disallowance of the expenditure was made in the 40A of the Act. It is also pertinent to mention that assessment year 18-19, the final assessment order was passed subsequent to the impugned order passed under 263. For the aforesaid reasoning and judicial pronouncements, I will quash the impugned or revision to order since AO has taken a plausible view and has not made disallowance of the impugned expenditure on 48. Last line sentence, we make it clear we have not considered the issue on merits, whether the impugned expenditure is commission payments or discounts. It is ordered accordingly. So, my lords, no one takes a conclusion, my lords, no one comes to a finding whether the expenditure is a commission payments or discounts today. And the tribunal also says this expenditure which the AO has not allowed today is commission expenditure or discount today. So one, my lords, I suffer because, my lords, AO does not tell me or AO does not possibly justify as to why he has passed an order saying that I'm not allowing them, disallowing this expenditure. Second, my lords, even if you have said, my lords, after looking at the record, nothing to show on record. Silence cannot speak, my lords, on the assessment order. So, my lords, AO has taken a view. AO has taken a view, my lords. Sorry, my lords, the principal commissioner has taken a view that there has to be a deduction made on the TDS, and hence he has passed the revision order on 263. Because every order of assessment, my lords, yes, my lords, assessment order, my lords, is at page 97, annexure D. Dissonance, my lords. Dissonance on only one aspect, my lords, that is commission of sales. I'll just exactly, commission on sales debited to the assessee's profit and loss account. It was like, discount was offered, my lords. And on discounts, whether it is a discount or a sales commission, my lords, was a subject matter of consideration. So should they have done a TDS or not was a subject matter. He says there was no need to do a TDS, the assessing officer. The principal commissioner says that had to be done, there had to be a TDS done on that particular sum of 36 crores. And then that has to be brought into the books and taxed accordingly is what the PCIT says. Assessment order does not say anything on that. Because the reason is also this, my lords. I can In failure, I'll submit, my lords. For disallowance, my lords, for not adding a sum, they need not be a reason at all given by the AO. But my lords, when the AO has called for records, when AO says, my lords, I am not satisfied with the initial, please give me all this justification. And then, my lords, stay silent on that particular issue, my lords, that causes a concern, my lords, for the department. Because, my lords, we have no option but to revise an order. I can't go and appeal, my lords, against my own officer's order. I only option available for me is, my lords, I have to do a revisionary order. That is the only option, my lords, that I have. Today, my lords, if I have exercised my option, my lords, for two reasons, because I say that it is erroneous. And I also say it's prejudicial to interest of the revenue because I've lost my money. The state has lost its revenue. Then, my lords, PCIT, my lords, in its discretion has passed an order in this nature. Whether a view taken or not, my lords, we don't know. Assessment, my lords. Yes, demand order. Yes, my lords. That's at page 113, my lords. The PCIT order. Yes, my lords. Order number 263. Please look at para 4, my lords. Again. The submission filed by the assessee have been carefully considered. Assessee's claim that this issue was considered by AO during assessment proceedings is not acceptable, considering the facts discussed above, particularly as the assessee has not filed necessary evidence along with sub reply to substantiate these claims. Considering the facts, it is clear that TDS was required to be done on 36 crore 34 lakhs 10,000 debited by the assessee to the profit and loss account towards commission on sales. As the assessee did not do TDS on this amount, the AO should have disallowed this amount under section 40 AIA. AO has not made the disallowance even though similar disallowance have been made. No, my lords, then at para in 8 and 10, my lords, they again substantiate the reasonings further to say why the AO should have done it. And my lords, even if the tribunal, my lords, had taken a stance saying that the AO somewhere had taken a possible view, my lords, I would have understood. But my lords, being silent on the assessment order, my lords, then on what grounds can the assessment order even sustain? No, my lords, what is more important, my lords? In the impugned order, my lords, that is a PCIT order, all that the PCIT says is to relegate the matter to the assessing officer, giving opportunity for both parties to substantiate. Yes, my lords. My lords, question is, my lords, whether he applied his mind, my lords, I don't know. Yes, my lords. My lords, I don't know, my lords. Yes. Yes, my lords. Assessment order. Annexure D, my lords, page 97. D. It runs up to 16 pages, my lords. At least, my lords, I was not able to find any reasoning on, my lords, on this particular dissonance. No, there are one heading, my lords, that's on depreciation of goodwill, my lords, page 99. That was one of the heads. No, that is one head, my lords. No, my lords, that's a different issue. That's a different issue, my lords. So he passes an order, my lords, on goodwill and slum sale in page 99. He also passes an order, my lords, depreciation and goodwill arising from amalgamation at page 104. But on this issue, my lords, on the dissolution on the commission, there's not a finding, my lords. So subject to what sir says.
An assessment, the officer for various details examines various states that are made. Where the assessing officer does not agree with me and wants to make any addition or disallow any expenditure, only then he discusses that in the assessment part. If I make some submission and he accepts it, he doesn't normally discuss that in order. So presumption in law is, and there are judgments to take. And if the assessing officer makes an inquiry and does not discuss it in the order, the presumption is that he has accepted my explanation and decided the issue. That's the presumption. I mean, any number of decisions, and that's what the tribunal has also followed. Because In an assessment order, the assessing officer never discusses if Malot has any assessment order passed. In fact, my learned friend himself submitted it very clearly. That when making pay and accepting my submission, he doesn't have to discuss that in the assessment order. In the assessment order, all that assessing officer does is if he's making, is not accepting my reply and making an addition or making a disallowance.
Based on what has not been said. The rule is taken by the magistrate. In contrary, it is.
No, so the thing is this. I have made the assessing officer, my friend also will agree, and the tribunal has very clearly noted that during the course of assessment on this issue of tax deduction on commission or discount, whatever the case may be, the assessing officer did an inquiry. He asked me a question as to why I have not deducted TDS on these amounts. I gave an elaborate reply saying that I am not liable to deduct TDS on these amounts. He has accepted it. He has not discussed it in the order because that's not a practice in any field. Now the commissioner says, what does the commissioner say? Commissioner does not say basis the submissions I made before the assessing officer that my claim ought not to have been accepted. All that the commissioner says is, in the earlier years, these amounts have been disallowed. You should have also disallowed it. That's what the commissioner says. Malot's kindly recollect what my learned friend has read. The commissioner does not basis my submissions made because all the submissions are on record. My submissions, my
How would you treat that argument? Previously, it was not. Previous assessment.
Each assessment year is different. Assessing officer can, in another assessment year, take a different view. In view of the finding, in view of the case laws on the point, whatever the case may be. Each assessment year, that proposition I don't think even my learned friend can.
There should be a sum in the circumstance. In the previous assessment year, this assessment year, for him to take a different.
For every assessment year after this, they have not made any disallowance. If the same stand is taken, there were two previous assessment years where this issue was raised. After this year, after this,
Further 2 years.
Subsequent years, no, this issue was not raised at all.
No, subsequent years, my lords, for 16, 17, 17, 18, 19, this issue was not taken, my lords. Maybe they'll revise the subject again. I don't know, my lords. But as it stand today, my lords.
Even on merit, entire basis on which the earlier years disallowance was made was on the basis of idea singular decision by the Delhi Tribunal, which the Delhi High Court affirmed, which was reversed by the Supreme Court. So on merits also, I am bound to succeed. That's a different matter. But the thing is, whether 263, can you see the problem?
This year is 15-16.
15-16, my lords.
But before 15-16, a particular view.
Yes, my lords.
Onwards, it has been accepted.
My lords, in fact, 13, 14 and 14, 15, my lords, matter went to the tribunal. Tribunal, my lords, again sent the matter to the AO. So, my lords, for 15, 16, we have there, my lords, that status, I'm not sure, my lords. That's sure, I'm not. Yes, my lords. My lords, that's at page 17, my lords, the finding. That's the submission made by the DR, my lords, before the tribunal. Page 17, my lords. Page 17, my lords. 17. The fourth line from top, it is further submitted, fourth line, my lords, in the middle of the paragraph. The learned DR that for assessment year 13, 14 and 14, 15, the tribunal restored the matter in the appeal filed by the assessee to the AO to determine whether payments made by the assessee to distributors is discount or commission. Therefore, it is contained by the DR. Similar view may be taken for this assessment year also. My lords, I would not come in the way, my lords. In fact, yes.
In this case, 660 was invoked. We are only on 260. Was the commissioner right in invoking 260? Does he have jurisdiction to invoke 260 in the facts of this case? That's all is the examination that is required to be done. Kindly see section 260. If my learned friend
No, I have some. I'll just have some judgments, sir. I'll just finish it.
You have to go back. What are the powers of the commissioner? When can a commissioner invoke? Is it a fit case for invoking the examination? That's a question raised. What the tribunal says is, it cannot kindly use it with legal explanation to says, deems an order to be erroneous if there is lack of inquiry. This is not a case of lack of inquiry. If at all the commissioner feels that it may be, that also he doesn't say. He doesn't say there is inadequate inquiry. Commissioner said you have to make disallowance. Supreme Court in Malabar said commissioner cannot
Direct.
Substitute his opinion with that of the SC officer. That's what Supreme Court says. If AO has taken a view, commissioner cannot substitute.
The question is whether a view was taken or not. That is, my lord. That is a plausible view. The word uses plausible view. Now, my lords, there are few judgment, my lords, says when an issue has raised, then if an assessing officer calls upon a person to say, look, please give me certain documents, my lords, how will any revision authority will understand, my lords, what has gone in there? Some application, my lords, yes. Because, my lords, otherwise, well, otherwise look at the consequence, my lords. I have nothing, but loss of revenue will only happen at the end of the day. If every view, my lords, every decision, my lords, have two possible views, my lords. I am not on that. But my lords, that possible view, my lords, will have to be explained. But at least, my lords.
Officer, suppose they accept the view of the SSC. Does he say anything on that?
No, my lords. Normally they don't, my lords. Normally they don't.
That may be a ground for you to argue. Or where does the SSC officer say? The argument is SSC officer not necessarily have to say anything if he is accepting our view. Not said.
No, but if that particular view, my lords, but let's say, my lords, the silence on the face of it, my lords, erroneous. The silence of the assessing officer, my lords, in the assessment order, erroneous, my lords. Will I not be able to exercise my jurisdiction 263, my lords? The silence in their favor, yes. Yes, my lords. Then I get an option to exercise my jurisdiction to. Now, that, my lords, is based on what the law says, my lords. Let's say, my lords, in this case, they had to deduct TDS, is the contention. Now, my lords, here, the PCIT says, please deduct TDS. They have not done it, so they have to disallow. The income tribunal, my lords, does not even say finding on that. That is the problem, my lords. If the tribunal had taken an independent view, no, in this case, irrespective of what happens on the merits, I'm saying that on this particular issue, TDS was not liable to deduct it, then I have no case to stand on here.
Commissioner has said that. What I find, commissioner doesn't go into the facts and say, on this amount, TDS has to be deducted.
No, he says so.
He says because.
He says.
AO has not done it for the earlier 2 years, he has not done it for this year. But in this year, AO has accepted my submissions. What's wrong with it?
No, the reasoning, one of the reasoning is for previous assessment year, they have not done it. But his PCIT, my lords, has accepted exercise is right.
He has not, assessing officer has not committed now.
Yes. Yes, one of the reasons, yes, my lords. Yes.
Because they challenge it, IKP says a lot of inquiries carried out and he did not agree with the presumption except he has.
Because to what extent can you take the presumption to that extent, my lords, is something that we'll have to look at, my lords. Because a lot of cases, my lords, where this is a commonality, my lords, where no one challenges, my lords, as to why the officer is silent. And we also can't, my lords, otherwise the officer will be burdened with a lot of duties. My lords, in this sort of cases, my lords, I have some judgments, my lords, in my favor to show. First, my lords, some reasons must be sort of deciphered from the assessment order. Second, my lords, can the tribunal even sit in revision of a 263 order, my lords? The Telangana judgment says it cannot do so. Because, my lords, he is a fact, the PCIT, my lords, is a person who will have entire facts with in front of him. The Telangana High Court takes a contrary view. Tribunal, yes, my lords.
We don't know.
This is the record. Which record? The questions called for asked by by the assessing officer to be in the assessment proceedings and the response to the appeal.
Where are those reflected? Where are those shown?
My lords, those, my lords, yes, my lord. Right, my lord. Para 8, my lords, at page 21. Yes, in fact, sorry, my lords. I have to show, my lords, first is page 17, my lords, on 22/11/2018. A notice has been issued, my lords, calling for explanation.
There is a question asked by the assessing officer to me during the.
Page 17, my lords.
Yes, commission expenditure to the extent of 36.34 crores has been incurred during the AY and the consideration. Please explain in brief the nature of expenditure and also if TDS has been applied. So, assessing officer asked me this question during the course of assessment procedure. Kindly see my reply, para 7 extracted portion at page 18. Note on special discount. The special discount given to national distributors and regional distributors which are also its customers amounting to rupees so and so to its profit loss account. These amounts are not subject to TDS withholding tax provisions under the Act, as the payments do not qualify as commission but as discounts and accordingly should not be disallowed under section 48(1) of the Act. Transaction with distributors is in the nature of sales and not agency. Key features of the arrangement to the distributors for your favorable consideration. The company sells the goods to the distributors wherein the title, risks and reward stand transferred to such distributors on actual delivery of the goods. The goods sold by that company to such distributors is reduced from the company's inventory and reflected accordingly in its accounts as sales. The recovery against company's sales is not contingent upon the sales made by the distributors. The company only gives a discount to the distributors on the goods purchased by them. The distributors invoice the retailers, customers in their own names and earn a profit margin on each individual transaction. Sample copies of debit or raised by distributors to the company are enclosed for your reference. The sales made by the distributors are on their own account and hence the distributors bear the risk of bad debts in case of non-recovery. The distributor having purchased the goods from the company and having paid for it makes no difference to the company. The distributor keeps on holding the goods instead of selling them. There is no monetary loss to the company. The loss is to the distributor if he does not sell the goods. Any legal claims by the retailers, customers will be on the distributor and the distributor will then subsequently have a claim against the company. In other words, the retailers, customers cannot bring any legal suit against the company directly. The transaction between the company and the distributors is on a principal basis. The basic requirement, let's stop here. Basic requirement for TDS under 194H, which is what the department wants me to do, is that he should be my agent. This is on a principal basis, and I'm saying commission, the TDS provision is not applicable. That was long and short of my submission to both SCS. From the above, your good self would appreciate that all the constituents necessary for a sale transaction are present in the company's name, and the sale cannot be labeled as an agency agreement. Sale price discount by way of debit notes are discounts and not commission. The sale price discount is offered by the company to the distributors by way of debit notes issued to them towards the distributing the various schemes in the market in a particular period. The discount is to be offered may vary from one distributor to another distributor. Company outlined the important features of the discount schemes for your favorable consideration. The discounts are based on the volume of goods purchased in a particular period by the distributors as per the guidelines provided into the sales schemes. At the end of each period, as per the discount scheme, the company identifies the volumes purchased by a particular distributor to calculate the eligible discount. This discount is provided to the distributor by way of debit notes. The company verifies the claim as per the debit notes issued by the distributor and grants discount on satisfaction of the bill. The sale price discount is not offered on the face of the invoice due to the practical issue of determining the actual quantity purchased by the distributor, which is resulting at the end of the particular scheme period, which cannot be determined during the time of initial sale of goods. In this context, we wish to highlight the judgment of the Calcutta Tribunal in the case of Sorito as the decision. We have relied on various decisions. And kindly see para 8 at page 21. Not satisfied. This is what the tribunal notes. That AO conducted further inquiry, not it did not just stop with this reply. Not satisfied with the above reply, the AO issued another show cause notice on 12/12/2018, providing an opportunity to receive to justify non-deduction of tax and source on the above said commission payments. The relevant part of the AO show cause notice dated 12/12/2018 reads as follows. Special discount, the SC by submission dated so as provided in note of the special discounts given to its national and regional distributors amounting to so provided during the year under scrutiny. It is noticed that these payments are not subjected to withholding taxes. Further submission are reproduced below for perusal. The discounts are decided based on the volume of goods purchased in particular period by the distributor. The discount is provided in form of debit note. Further, sale price discount is not offered in the face of invoice. It is clear that the relationship between the SSC is in the nature of principal agent. He also says it is in the nature of principal agent, to which I further give a reply, and despite that he doesn't make an addition, which means that he has applied it. When debit note is issued, it means that the expenditure is 100% debited to books. Hence, it is evident that the distributors are getting discounts in lieu of commission, and it should be subjected to PDS under section 194H. Kindly see the reliance placed by the AO at that point in time. Reliance is placed on the case of Delhi Tribunal in the case of Idea Cellular. Calcutta High Court is the case of Bharti Cellular. Both these judgments subsequently reversed by the Supreme Court in my favor. I come to that. It's part of my comparison. I'll come to. In reply to the above show cause notice, the SC submits its contentions on 17/2018. Relevant portion of SC submission is reproduced below for ready reference. Note on special discount. Basically, I have reiterated what I had submitted earlier. And kindly see page 23. Penalty sample copies of agreements along with debit notes raised. I have given details of my agreements to see whether it's on principal or principal agent. All that has been given. Then I rely on Supreme Court judgment in Prasad Bharti Doordarshan, which is what was relied on in Idea Cellular, subsequently by the Supreme Court. I'll come to that. So I give a detailed reply there. Now can we see what the finding says at character? From the above show cause notices issued by the AO and the reply submitted by the SSC, it is clear that the AO has examined the impugned transaction in detail during the course of assessment proceedings for the year under consideration. The SSC during the course of assessment proceedings had also admittedly placed on record the distribution agreement and the debit notes. From this, the only inference that can be drawn is that the AO has taken a conscious decision in not making the disallowance under section 40A(1)(a) of the Act. Therefore, the BCIT's reasoning that the AO has not examined the issue in accordance with law and has not conducted necessary inquiries is incorrect. Since the AO has taken a plausible view, the said assessment order cannot be subjected to revision under section 263 of the Act. In this context, we rely on the judgment of the Honorable Apex Court in the case of Max India Limited. From the latest judgment of the Honorable Jurisdictional High Court in the case of Kemsworth, reported in so clearly held that the question where there has been an application of fine before allowing the expenditure has to be examined from the records of the case. It was further held by the Honorable Jurisdictional High Court that when the SSC has filed all the details before the AO and the AO has accepted the contention of the SSC, it is deemed that the AO has taken a plausible view in allowing the claim of the SSC. The relevant finding of the Honorable High Court reads as under. I'll just read that paragraph because our High Court follows Delhi High Court Sandeep. Sandeep Vikram follows a very old case of Bombay High Court. And this is the settled legal position as far as 263 is concerned. Paragraph 8. In the backdrop of the aforesaid well-settled legal positions, we may examine the facts of the case in hand. In CIT versus Sandeep Model Limited, it has been held by the Delhi High Court that assessing officer in the order of assessment is not required to give detailed reasoning in respect of each and every item of deduction. And therefore, the question whether there has been an application of mind before allowing expenditure has to be examined from the record of the case. This is what Delhi High Court says, and which has been followed by this High Court. The question of lack of inquiry, inadequate inquiry is also required to be kept in mind, and mere inadequacy of the inquiry would not confer jurisdiction on the Commissioner of Income Tax under section 263 of the Act. It is clear from the section itself, which I point out. In the instant case, the Commissioner of Income Tax has held that the inquiry assessing officer, and the assessing officer has accepted the contention of the assessee that no expenditure is attributable to the exempt income during the relevant assessment year. Thus, while recording the aforesaid finding, the assessing officer has taken one of the plausible views in allowing the claim of the assessee, and therefore the Commissioner of Income Tax should not have set aside the order of assessment merely on the ground of inadequacy in inquiry. The order of the passed by the Commissioner of Income Tax is not sustainable in law, and the same has rightly been set aside by the Tribunal. Moreover, from the report of the AO submitted to the learned heir, it is clear that for the assessment years 2016, 17, 17, 18, 19, the commission expenditure was not allowed in the final assessment orders completed for those assessment years. It is pertinent to mention that for the aforesaid assessment years, the AO had called in question the allowability of commission payments during the course of assessment proceedings, and the assessee had filed similar reply as it filed for the impugned assessment year. However, no is filed.
My lords.
That's what we should have done actually under this history, not just setting aside the order saying you should have done it. If at all error has to be, there are two types of errors. One is error of not inquiring at all. That I accept not section itself. Therefore, your worship can see section 263.
But the only thing, Mr. Sulman, is not my own. But there should be something to show there is some application of my own any aspect.
Usually in all the revenue matters, whether it is direct tax, indirect tax, or it is the inquiry. That is why Delhi High Court says whether inquiry has been done is not to be seen from the order but from the record. Because where my claim is accepted, it does not have to come in the, it does not, in fact, my learned friend also says it doesn't come in the order.
See the consequence of this. Not being there, one, the thought is there is no application, there is nothing considered.
No, so therefore, Manor 263 itself says that the commissioner can invoke jurisdiction where there is lack of inquiry, only.
Based on record.
Based on record, yes. If based on record he comes to the conclusion, if can be seen that there is inquiry, then he cannot invoke the rule.
So some substance is this, you will independently the appeal or the record, you will see the other record also, then come to a conclusion.
They have to come to the conclusion that inquiry has been done. If on facts, let us say on facts, let us say tribunal, if the commissioner had said, no, this tribunal order is there, Idea Cellular by Delhi Tribunal and Calcutta Bharati Cellular is there, and that has been affirmed by the High Court, you should have followed it. All that is not coming out in the order. And ultimately, like I said, on merits, in any case, ultimately the decisions being relied upon in the earlier years or by the assessing officer have been reversed by the Honorable Supreme Court on merits also in favor of the SSC. They have said discounts cannot be said to be in the nature of commission, and for commission for 194H to apply, there has to be a principal agent relationship. So all that the commissioner has not.
Principal to your case is principal to principal.
Principal to principal.
Because that, my lords, there's not an order, my lords, to show as a principal to principal. That's a fact, my lords, that an assessment officer will have to look into it. Well, more importantly, my lords, may I say this, my lords? What fell from my lordship, my lords, as to the reasoning under 263, my lords, that this is a, because I have a judgment of Justice Sikri, my lords, which actually says what my lords is thinking today. Yes, my lords. My lords, there are two ways of also looking at it, my lords, because most of the time, with yes, my lords.
There. What is being argued is that you will still see the record which was there, and for the authority to come to a conclusion that this aspect was brought into, possibly agreed with the SSC, hence no finding.
Yes, my lords. In fact, in the judgment, my lords, the tribunal has relied upon, that is comes forth, my lords, there, The assessing officer had taken a view, my lords. That's the reason. That's a plausible view was taken. Please look at, my lords, the paragraph that the court relies upon. I'll just read, my lords, last 4 sentences. So here is a case, my lords. Because here is a case, my lords, where the view is itself is not known. And the other case, my lords, where the jurisdictional high court, the view is different, my lords, because the AO is categorically stated, as per, my lords, it says. My lords,
What has been reflected in the IDAD order? Which you are not denying.
I'm not denying, my lords. The record speaks for itself. Yes, my lords.
The finding or the observation which have been made by the IDAD.
Because what I'm contending is the fact that today, my lords, that there is a possibility, my lords, show cause notice was issued, reply was failed, came to him, my lords. But we do not know, my lords, what has transpired between that reason as to why the AO did not let it go. Because, my lords, he was also under the old impression, my lords, for 13-14. And for the 12-13, there was an order to say that you have to do the other way around, not this way around. Because that, my lord, is something that we'll have to see, my lords. Because for the tribunal has set aside the order. Yes, my lords. Yes, my lords.
The Supreme Court has now reversed it. Then the position is what has been held here now.
By the tribunal, yes, my lords. I'll go down to that, my lords. Because may I, my lords, in that event, my lords, I'll check up, my lords, as to what has happened to this loose-ended corner today. Yes, my lords. Maybe, my lord, I'll also check with the officers, my lords, whether they really applied this particular piece of law to the assessment order, my lords. I'll. You just sent one, my lords.
These orders.
The
There are any number of high court cases. Our high court also has taken the view. That went to the Supreme Court. Karnataka High Court, you have to take view in favor of the SC. Delhi High Court, you can view against the SC. All the matters went to the Supreme Court, and Supreme Court ultimately made it in favor of this.
Much before this.
Supreme Court has come this. Otherwise, high court decisions were there in favor of this. But otherwise, even otherwise, Manoj, kindly see section 263 further. Because ultimately we are looking at the commissioner jurisdiction under section 263. What is the commissioner's jurisdiction under 263?
Yes.
Division of orders prejudicial to revenue. Manoj,
That he has expressed.
no. I just come. Can I see what is it that the commissioner has to examine? Has he done that in this case? He doesn't examine the record. Can you see the principal chief commissioner or principal commissioner or commissioner may call for and examine the record of any proceeding under this act, and if he considers that any order passed therein by the SC officer or the transfer pricing officer, as the case may be, is erroneous insofar as it is prejudicial to the interest of the revenue, he may, after giving the SSC an opportunity of being heard and after making or causing, he made such inquiry as if he has to do an inquiry. Pass such order thereon as in the circumstances of the case justified, including an order enhancing or modifying the assessment or cancelling the assessment or directing the assessment or not. And you see what is record? Explanation 1, clause B. Record, definitely it's also defined. Record shall include and shall be deemed always to have included all records relating to any proceeding under this act available at the time of examination by the principal commissioner or principal commissioner or commissioner. And most importantly, kindly say explanation 2. Explanation 2 says, for the purposes of this section, it is hereby declared that an order passed by the assessing officer or transfer pricing officer or as the case may be, shall be deemed to be erroneous insofar as it is prejudicial to the interest of the revenue if in the opinion of the principal chief commissioner or principal commissioner or commissioner, the order is passed without any inquiries or verification which should have been done. The order is passed allowing any relief without inquiry into the claim. So his jurisdiction, he can treat an order of the assessing officer as erroneous only when there is no inquiry at all. That is what the expression 2 says. Here is a case where there is inquiry. It may not have been, he may not have expressed his view. He need not, when he, like I said, when accepting my view, he did not express it in the assessment order. Only if he is disagreeing with me, he has to put it in the assessment order because I have right of appeal against that. And can you see what
But that wording is not used. The issued a show cause notice. He's issued a show cause notice, my lords, but yes, my lords. He's issued a show cause notice.
Also see what has been done by the ITA. These were the thought, these are what the manner in which the assessing officer has done the inquiry and then come to a court. He should have said the.
Yes.
See, there has to be finding of fact.
Fact.
That the assessing officer has not carried out the inquiries on these aspects. And he is also not, what is being argued from Mr. Sundararajan is, even though the assessing officer does not reflect in the order, but if he has made an inquiry, at least
Sufficient.
will suffice.
even though his view may be wrong, that is what the Supreme Court says. Let us say, my lord, in all tax matter, in any matter, my lord, there are always two possible views. Whether it is discount or commission is a debatable issue, depends on the facts and circumstances of it. Supreme Court in Malabar says, even if the assessing officer has taken a wrong view, he has taken a view. That view cannot be substituted by the commission. Kindly see Malabar for a moment. Because that's the starting point of this. If it is a purpose, so he has to say how it is purpose. That has to be there in order. That was the right.
First view is not based on inquiry.
Yes, yes, of course. That of course, but plausible view, that is what, of course.
Other two views, one view possible.
The very fact that this issue of discount commission was deliberated by so many tribunals, so many high courts, ultimately settled by the Supreme Court, shows that it is a matter which has to be.
Yes, my lords. My lords, I will, my lords, check, my lords, whether the PCIT did call for the records or not, because they would not work other way, my lords. Every PCIT officer, my lords, would call for the record from the assessing officer when he has to pass a 263 order. Maybe, again, my lords, is not reflecting in the order, but I'll check, my lords, whether. Not the recalling for records, my lords, but I'll just see, my lords. Yes, my lords. Because what I'll check, because my lords, without revision, my lords. Tomorrow, my lords. I have four judgments, my lords, not more than 4 paragraphs, my lords. First one. 330. Yes, miss. All right. Yep.
ಅಲ್ಲ ನಾನು ಹೇಗಂದ್ರೆ ಟೈಮ್ ಅಂದ್ರೆ ಟೈಮ್ ಹಾಕ್ಸ್ತೀನಿ ಅದಕ್ಕೇನೆ. ನಾನು ಹೇಳುದು ಟೈಮು ಇನ್ನು ಬೆಳಗ್ಗೆ ಬೇಗ ಎಲ್ಲ ಮುಗಿದೋಗ್ಬಿಟ್ರೆ ಆವಾಗ ಕಷ್ಟ. 3:45 ಇವ್ರು ಕಾಯ್ಕೊಂಡು ಇರ್ಬೇಕು. ಸರಿ ಅದೇ ಬೇಡ ಬಿಡಿ ಮೇಡಮ್, ಹಾಕ್ಸ್ಬಿಡಿ.